Hi, Judge.
Hi, Quello.
Hi.
Because I had to move rooms, I've lost Sir Christopher and Sir Morris. So,
Okay, let me put you in the breakout room. Here you go. Right, good morning, everyone.
Good
I
morning.
do see that we have co-ed facilities online, but I do not see Westgate. Although I do see someone called corrections, which I assume is Westgate. All right, good morning. Today is Tuesday, the 8th of June, 2021. This is the Court of Appeal assembled for the Criminal Appeals number 2 and 5 of 2020. Katrina Burgess and Cleveland Rogers against Her Majesty the Queen. The proceedings are taken before my lords, the Queen's Justices, Sir Christopher Clark, the President, Justice of Appeal Morris Kay, and Justice of Appeal Jeffrey Bell. Mr. Charles Richardson of Compass Law Chambers is representing the appellant, Ms. Burgess, and Ms. Susan Mulligan is representing the appellant, Rogers. Mr. Carrington Mahoney and Ms. Karen King-Dean are representing the Crown. My Lord President.
Well, good morning to you all. I'm sorry we have been slightly delayed. Before we start, there are two matters that I need to raise. The first is the reported evidence of the juryman. Mr. Daniels' affidavit reveals that he was told by a juror whom he recognized at a garden center, that the jury was split right down the middle, and those in favor of acquittal just decided to go along with those in favor of conviction in order that they could get home that night rather than be put into a hotel. If that was true, it was, amongst other things, a breach of the juror's oath. But it appears to us that it requires examination, and that begs the question as to what form of examination, on which we would invite submissions, not necessarily immediately, but at any rate, if possible, sometime today. What we have it in mind is first to ask the registrar to question the forelady of the jury, and then, if needed, the juror who spoke to Mr. Daniels, possibly others. That, of course, means finding them. It should be possible to find from the records who was the forewoman. What might be more problematical is to identify the male juror. I don't know whether Mr. Daniels knows his name. He may well not. There may have to be some investigation. If there's somebody still at the garden center who was a juror, we'll find him by that means. That might engage some difficulty. That's a process we can start on forthwith, but I suspect it can't be concluded within the 4 days we have set aside for the hearing. I mention this now so that counsel may have the opportunity to make submissions as to what we should or should not do, and so that we can set matters in motion. We may need to come back to this aspect of the case after the 4 days that are presently set aside for the hearing have taken place, and after such investigations as we decide to carry out have taken place. That's item number one. The second item is the question of severance. One of the grounds of appeal is that there ought to have been severance between the two appellants. It's not, however, apparent to us whether there was actually any application to the court. There should be severance. If there was such an application, it would seem inconceivable that there wouldn't have been a ruling which would be recorded and would almost certainly contain reasons for the ruling. But so far as we have been able to discover, there is no such ruling, and we suspect that there may never have been an application for a severance. So we need to know whether or not he said that there was in fact an application, or whether or not what is effectively said is that the judge should of his own motion have severed the two defendants without being asked so to do. So those are my preliminary points. I don't know whether anyone wishes to make some observations immediately upon them.
Good morning, my lords.
Good morning.
My lords, I will make observations first. With respect to the issue, as my lord colloquially phrased it, of the juryman, I did have some discussions with Ms. Mulligan prior to this hearing, and we actually agreed that the route that his lordship has just sketched out is indeed probably the route that should be followed.
So for the registrar to interview the forewoman, and then, if necessary, the juror.
Yes, my lord. I would say that interviewing the actual juror might actually be necessary.
Yes, it might.
Because
Okay.
it might be that even if the foreperson did not feel pressured, if that juror himself felt pressured, that would be matters that their lordships would wish to take into account.
Yeah. Okay.
So I have no difficulty with the first proposal that his lordship has made.
Right.
With respect to the second issue that his lordship raises, there was in fact a severance application. However, it took place sometime before the trial commenced, before a different judge. And the practice in this
Who was that judge, Mr. Richardson?
it would be Justice Simmons, my lord Bell.
Right.
Ideally, it should have been taken by the trial judge, but it was anticipated at the time, I believe, that Justice Simmons would be the trial judge.
So it was before the start of the trial that came to be.
Before the start of the trial, yes, my lord. And at the trial, that application was not renewed because of a practice that I'm aware of, and everyone in this jurisdiction is aware of it, although some of us don't agree, that if one Supreme Court judge has made a ruling, that it is impermissible for a subsequent judge of the same jurisdiction to reverse that ruling, because they would be sitting in appeal of a judge of the same level.
So did Justice Simmons refused to sever, is that right?
Yes, my lord.
Did she give a ruling other than saying, I'm not going to sever?
I'm not sure if she reduced it to writing, my lord, but she made the pronouncement in open court.
Well, wait a minute. Making the pronouncement could simply be the application to sever is dismissed, or
Yes.
the application to sever is dismissed for the following reasons. Do you know which category it was?
I believe brief reasons were given, but they may have been extempore, my lord.
Yes, yes. Well, presumably you can find out the date on which that occurred.
I can set about to find out that date, yes.
Could you
my lord.
please
In actual
do
fact, I suspect that Mr. Coelho may be able to locate that from the Court Smart record, because as I'm aware, all the Court Smart recordings, although not stored in the same place, would have the same file number.
Well, Mr. Coelho has many abilities, but
Yes, my lord.
I think it would help if you were able to identify the date.
Yes, my lord. I will endeavor to do that, although
to try and make matters easier.
Yes, my lord.
Okay. Thank you. Ms. Milligan, I understand that you are in agreement with our proposal.
Yes, I am. I did have those conversations with Mr. Richardson. I think it's the only way to go about it. So,
Right. Okay. Mr. Mahoney, do you have any observations to make?
I do not agree, sir. I've made some preliminary submissions in the body of my submission, sir, and I will address the court further on it if it so please you.
Well, I think it would be useful to know at this stage, in fact, Mr. Mahoney, because what I think my Lord President has in mind is that steps will proceed.
Ah, yes.
Well, my lord, it's essentially, and I'm just going off from memory from my submissions, the authority seems to be clear that in respect of the jury finding, where the jury have delivered their decision, and if there is no indication of any dissent at the time that the verdict is given, unless there is some exceptional reason, there should be no attempt to go beyond the verdict of the jury.
Wouldn't the matter, Mr. Mahoney, that the juror raised to Mr. Daniels constitute exceptional reasons?
Not in accordance with the authority, sir. It's an involved area, sir, and I'm trying, I'd have to, may I just scribble in again, sir?
Yeah.
At page 30 of my submission, sir.
Mm-hmm.
Yes.
Submissions. Amended submission, sir. Under the heading Ground 6, Burgess, Ground 5 and 6, Rogers, jury pressure. May I continue, sir?
Yes.
The respondent submits that after the verdict had been delivered, to which none of the jurors indicated any dissent when it was delivered, and when asked, evidence directed to matters intrinsic to the deliberations of the jury is inadmissible. This is paragraph 17
Yes.
of the respondent submissions. Paragraph 18, the rule against any investigation or inquiry into jury deliberations is a rule of admissibility. Evidence about the deliberations of the jury is therefore inadmissible. 19, the rule is subject to two narrow exceptions. The first arises if it emerges that there may have been a complete repudiation of the oath taken by the jurors to try the case according to the evidence. Examples include a decision arrived at by the casting of lots or the toss of a coin or the use of a Ouija board. The second exception arises where extraneous material has been introduced into the jury deliberations, such as telephone calls out of the jury room, discussions between jurors and relatives or friends about the case, and information derived by jurors from the internet. Paragraph 20, the respondent submits that the affidavit of Mark Daniels, lead trial counsel for the appellant, that's applicant Rogers, is not fresh evidence.
Why is it not fresh evidence?
Well, the authority suggests that it is inadmissible hearsay.
That's a different question, but it must be fresh. It only came into existence when Mr. Daniels went into the gardening centre.
So I would have to go through the authorities. I wasn't prepared to go through the submission.
I mean, that's a straightforward question, Mr. Mahoney,
Yes.
which you'll agree it's fresh evidence, will you?
On the face of it, sir. But it is inadmissible, sir.
Well, that's a different
Right,
question.
that's a different question.
It's inadmissible hearsay, sir, at best.
Well, wait a moment. There are two, when you say inadmissible hearsay,
And I continue, sir.
yeah,
The respondent further submits that even if the affidavit was produced by the mystery juror himself, the said evidence seeking to inquire into the deliberations of the jury did not fall within any of the two narrow exceptions and is therefore inadmissible. The respondent submits that
Well,
along
we needn't go into 21 because that's simply a long retirement question. But you say it doesn't fall within the narrow exceptions. But if one of the narrow exceptions is a complete repudiation of the oath taken by the jurors, if 6 of them decide, well, what we actually think is that he should be acquitted, but we really can't face going into a hotel this evening, so we'll agree that he should be convicted, it's difficult to conceive of a more obvious repudiation of the oath taken by the jurors to try the case according to the evidence.
From that perspective, yes, my lord. However, there is abundant authority that deals with the issue of where a juror has changed their mind after the verdict.
That again is a different issue, it seems to me, but no doubt you'll take us to it.
Excuse me, sir?
This isn't a case where the jurors are said to have changed their mind after the verdict. It's a case what they are said to have done is half of them to have made up their minds and then produced a result or agreed with a result which was the precise opposite of what they've not made up their minds about.
Well, it is our submission, sir, that what this particular mystery juror seems to be suggesting is that he may have had a change of mind because the verdict was unanimous in respect of both appellants, and when asked if that's the verdict of all, nobody raised any dissent.
But it's a question.
So
that's not what
ahead.
He suggests. What he suggests is that before the verdict was given to the court, half of them were in favor of acquittal and half of them were in favor of conviction. But the ones who that meant that they were torn, that was likely to mean that they would have to be shacked up in the hotel for the evening, and that caused those who were in favor of acquittal to decide to convict simply to avoid being put in a hotel. Now that may or may not be right, but if it is right, isn't that one of the clearest possible examples of a repudiation of the juror's oath?
that is true, sir.
Well, we better investigate whether that is true, had we not.
Yes, sir. And the route that has been used in regards to these jury matters have been for the registrar.
Yep.
I think I have several examples in which a registrar has been.
Yep. Well, that's what we proposed.
Yes, very well, sir.
Okay. Thank you very much. Now we can begin the appeal proper. Thank you all.
Morning, my lords. I believe that I am up first.
I think you are.
Yes, sir. My lords, I would assume you are in receipt of these submissions that were filed some time ago.
Not merely are we in receipt of them, but we have read them.
I'm sure my lords have. My lord, I will begin and I will follow the format in the submissions. Of course, I will make small segues when necessary, but I will try to stick to the body of the submissions because I do believe that they do thoroughly cover most of the points, if not all of the points. In the background, my lords, the appellant, Ms. Burgess, was convicted on the 4th of March, 2020, with the charge of premeditated murder, contrary to section 286A of the Criminal Code, pre-amendment. You'll note that it says pre-amendment, my lords, because you'll probably be aware that that particular offense has now been removed from our criminal code.
Yes.
The learned trial judge in our submission made several sorely misconceived and erroneous findings in respect of key matters of law that resulted in the appellant Burgess suffering the gravest of injustices, a wrongful and unsafe conviction in respect of the charge of premeditated murder. Now, my lord, when we turn to the grounds of appeal, you'll note that ground 1 deals with the issue of severance, which my lords have expressed an opinion on, and I have further action on that on the day. Ground 2 deals with the issue of the application for stay of the proceedings on the basis of abuse that was rejected by his lordship. Ground 3 deals with the rejection of the application that we made that Ms. Burgess had no case to answer. What I can say now about ground 4 is that we are not pursuing that ground in that form. We are not pursuing ground 4.
Right.
We do not intend to ask their lordships to wade through the respective hearsay evidence of several, and you'll notice that in the body of our submissions, we haven't really addressed that point.
Right.
Round
Okay.
5, that the learned trial judge erred and he failed to order that the evidence of Katrina Card should be redacted to ensure that no reference was made to the appellant Burgess. Round 6,
Just a moment. Was he asked to do that?
sorry, my lord.
Was he asked to do that?
No, my lord. He wasn't asked to do that during the trial. My lord, ground 6 is that section 532 of the Criminal Code, Act 1907, is unconstitutional inasmuch as it prevented the separation of the jury after they began deliberations. And in the circumstances of this case, it rendered the trial process unfair. Ground 7, that the cumulative effect of the late disclosure coupled with the pre-existing delay caused unfairness and should have resulted in a mistrial. Round 8, that in all the circumstances, the totality of the admissible evidence against Ms. Burgess was insufficient to safely convict her, and the conviction of Ms. Burgess is therefore unsafe. Now, of course, my lords,
Mr. Richardson, is there any difference between ground 3 and ground 8?
well, my lord, in the body of these submissions, what you will find is that we concede that grounds 7 and 8 are actually subsumed within our submissions on other grounds.
On grounds 2 and 3.
Yes, my lord. Thank you. The next thing that I think I would need to do for my lords, and there may be some differences between myself and the Crown on this, is to sketch out what we say is the prosecution's case against Ms. Burgess, or was their case against her, taken at its highest.
Just before we do that, can I give notice of a particular matter, or to all parties of a particular matter with which I am interested? In the course of his summing up at page 336 and 7 of the summing up in the record that we have, the learned judge said in terms that Rogers could not be convicted of the murder in question, save on the grounds of, in reliance on the evidence of Miss Card and Miss Foley, and that such evidence was not admissible against Miss Burgess.
Yes.
That's what he said in terms. What is going through my mind is whether in those circumstances there was any evidence admissible against Miss Burgess that Mr. Rogers had committed the murders in question. And that's question number 1. And if the answer to that question is no, there was no such evidence admissible against her, that he had murdered, the Rogers had murdered what I will call Marcus. If there was no evidence of that admissible against her, could there be a conviction that she had assisted in a murder which, so far as the evidence against her was concerned, had not been shown to have occurred?
My answer to that question, my lord, of course, would be no.
Well, I thought it would be.
But in actual fact, that's exactly what happened in this case. As I develop the submissions, you'll see that that is exactly what transpired. In fact, for ease of reference, what we've done is we've tried to separate the Crown's case against Miss Burgess into 3 limbs so that they can easily digest it. The first limb, my lord, of the Crown's case against Miss Burgess was in fact comprised of several background fact witnesses. In fact, a large number of the witnesses called against Miss Burgess came to give what we call background evidence. It is, and I think in this case was, a vehicle used to smuggle before the jury information that wasn't relevant, but in any case, it was there. Those objections were made, but I will not pursue them at this stage. So I've abandoned ground 4. These witnesses, my lords, included, but they weren't limited to, Darwin Staple, Belinda Cameron, Karen Solis, Dawn Phillips, Donna Daly, Ricky Tucker, and others. Taken at its absolute highest, my lords, it's our position that the crux of the background evidence adduced by the prosecution against Ms. Burgess was such that it was open for the jury to find that the deceased and Ms. Burgess had an acrimonious relationship that involved typical relationship drama, such as infidelity, breach of trust, and heated arguments, and that not long before the deceased was murdered, she and the appellant, Burgess and the appellant had broken off their relationship, and the deceased had moved out of the apartment that they had previously shared at 10 Derwent Lane. That's the first limb of the Crown's case. The second limb of the Crown's case, my lords, is that in respect of a telephone call, and these are important items, that she made to the deceased at 7:15 p.m. on the night that he was murdered. The Crown relied upon the evidence of Mr. Michael Pierre and Miss Musson Pierre for this purpose, and I'll take you to his lordship's summation of their evidence momentarily. Mr. Pierre maintained that he had heard the appellant Burgess's voice on the telephone when Mr. Gibbons received the call at around 7:15 p.m. on the day he was murdered. Moreover, Mr. Pierre confirmed that after the deceased hung up the phone, he, Mr. Gibbons, told Mr. Pierre that it was Miss Burgess who was on the phone with him and that he, Mr. Gibbons, was to meet her at the apartment. Now, there's some dispute as to whether or not that was what Mr. Pierre said, and I'll take you to his evidence. It doesn't appear that he went that high. Taken at its absolute highest, the evidence of Michael Pierre, and we're giving it all the benefit that the Crown could possibly extract from it, without more, and subject to the arguments advanced in respect of ground two, enabled the jury to conclude that the appellant Burgess made a telephone call to the deceased at 7:15 p.m. on the night of his death, arranging to meet him. We actually don't resile from that. She did make that phone call at 7:15 p.m. and she did agree to meet with him. The crucial distinction, and it is very crucial, is where that meeting was to take place, because it is the Crown's position and it is the crux of their case on the admissible evidence against her, that she arranged to meet him at 10 Derwent Lane specifically and nowhere else. And the reason she arranged to meet him at 10 Derwent Lane, according to the Crown, is because she was aware that her brother or half-brother, the evidence on that is, again, unconclusive, was going to be there, according to the Crown, to kill him. If I could take you at this stage, my lords, I think I need to take you to the summation that his lordship gave. And for the most part, my lords, we don't take issue with how his lordship summed up the facts. He actually seems to have gotten that fairly good. We don't have many complaints about that, but I believe that my lord begins to sum up the evidence of the Pierres at 148. And at line 4, he begins, all right, I'm now going back to Michael Pierre's former wife, Michelle Musson Pierre, and what they had to say about their dealings with Marcus on the 25th of October, 2006. Mr. Pierre, you'll recall, indicated that he and his wife had been off island in Las Vegas and returned to Bermuda on the 25th of October, 2006. Whilst they'd been off island, Marcus Gibbons had use of the car, the red Opel Astra. He said that was because he was using it to move out of the apartment he shared with. Of course, it was later confirmed that he could have just used his work van for that purpose, but I'm not sure how much really turns on that in the grand scheme of things. You'll recall that Catherine Fisher, formerly Wolseley, told you she was at work on the 23rd and 24th at CCF with Marcus, and on both days, Marcus left work early to go and deal with his personal matters at his old Derwent Lane apartment. He left the office around 3 p.m. both days, she said, and the reason being that he wanted to avoid any conflict while getting his things out of the apartment. The implication being, it's a matter for you, ladies and gentlemen, that he was seeking to avoid any conflict with Miss Burgess. Anyway, Michael Pierre said that Marcus was glad to be moving out of the apartment with Katrina. and that when the Pierres left for Las Vegas, he was on the verge of moving out of the apartment, which again would suggest that Marcus had moved out considerably earlier than Miss Burgess told her Aunt Kendra. But Michael was not even sure if Marcus had already moved out by the time they returned. Anyway, as a result of having their car, Marcus was supposed to pick up Mr. Pierre and then his wife from the airport. He was able to do so because he got stuck in a meeting. So Mr. Pierre's stepdaughter collected from the airport instead, and it was later that day Mr. Gibbons came to the Pierre's house to drop the car off. Mr. Pierre then drove Mr. Gibbons back to his job. Originally, Mr. Pierre said that during the drive to drop Mr. Gibbons back to his job, that Mr. Gibbons indicated that he was going to meet the Beast later that day. The Beast being the nickname they had for the defendant, Miss Burgess, which they used behind her back. Mr. Pierre said that he asked if Marcus needed help or company in respect of this meeting with Miss Burgess, but Marcus declined. You'll recall that later, ladies and gentlemen, in cross-examination, Mr. Pierre was referred to his police statement and confirmed that in fact, he did not have a conversation with Marcus in the car about meeting with Miss Burgess or the Beast, and that's important. I think, although it's ultimately a matter for you, that perhaps he was confusing what he says Marcus said to him later, after Marcus had fixed the computer at his home. It has, after all, been some 13 years since these events, with the resulting difficulties that I have previously instructed you about in respect of delay. Mr. Pierre described the clothes that Mr. Gibbons was wearing, accepted that when he was found dead following the following day, Mr. Marcus Gibbons was wearing the same clothes he wore to work and was seen wearing by Mr. Pierre on the 25th of October. And you recall Michelangelo James tell you that Marcus would never wear the same clothes to work 2 days running. Subsequently, Mr. Pierre described Marcus returning to the home later that evening to help him and his wife fix the computer. The computer, he said, was in a corner of the same room where he was sitting on the couch playing FIFA on the PlayStation. After fixing the computer, Marcus had come over to the couch and was teasing Mr. Pierre. He said about his next wife, the PlayStation, when Marcus received a call on his cell phone. Mr. Pierre demonstrated for you that Marcus was standing right behind where he was seated on the couch, and he said he paused the game when the call came through on Marcus's cell phone and the room was in silence. Mr. Pierre said he heard the person on the other end of the call say, "Where are you to?" And Marcus replied, "At the Pierres, I'm with Michael Pierre." He said he recognized that voice on the phone as Miss Burgess's from talking to her previously and from prior occasions that he was present when Marcus and Miss Burgess were arguing on the phone, and Marcus would put the phone on speaker. There is in any event, ladies and gentlemen, no dispute that there was a conversation between Marcus and Miss Burgess while she was at the Pierres, and that is further confirmed by the telephone records, which indicate a call of 1 minute and 2 seconds duration between their two cell phones at around 7:15 p.m. on October 25th.
Just a moment.
Sorry, my lord.
There are references from time to time to two telephone calls. One is at 7:51.
The other's at 9:07?
Sorry?
The other's at 9:07.
No, well, I'd seen references to one at 7:15. I just wonder whether the 51 there is the right.
It could be a typo, my lord. That could be absolutely correct.
That's the accurate time, sir. 7:51 p.m.
It could be a typo somewhere else that his lordship is actually recalling.
Well, I think it might be in your skeleton.
Yes, my lord, that's entirely possible as well.
Yes, the skeleton does say 7:15 in paragraphs 6 and 8.
Yes. Then it would be a typo in my skeleton, my lord, and I would refer or rely on his lordship's summation.
I see. So that's right. So that
The
should
number
be
should be inverted to be 15 instead of 51.
Should be
Sorry,
51.
51 instead of 15.
Yes.
Sorry, I got lost. Say it again more slowly.
The number should be inverted in my skeleton to read 15 instead of, sorry, 51 instead of 15. So I've gotten the 1 and 5 wrong.
So that's in 6-8 again in 10.
So on any reference where I've used 7:15 in my submissions, then I've erroneously inverted the numbers and should have put 7:51. in any event, nothing turns on it. The time difference, nothing turns on it.
Right. Okay.
Yes. My lords, his lordship continues. What is in dispute, of course, and is a matter for you to consider as the triers of fact, is what was said and what is the significance of what was said. According to Mr. Pierre, Miss Burgess asked Mr. Gibbons, "Are you still coming over?" And Marcus said, "Yes." Mr. Pierre said that Miss Burgess started mumbling something and he couldn't hear the rest of the conversation. That's important too. You'll remember that in cross-examination, having confirmed that he was 100% sure that Miss Burgess said, "Are you still coming over?" It was put to Mr. Pierre and he accepted that. In his police statement dated the 26th of June, 2019, he stated that Miss Burgess asked Marcus, "Am I still meeting you?" And he adopted that as his evidence.
Right.
And not, "Are you still coming over?" And ultimately, Mr. Pierre, while conceding that he could not recall the exact words of the conversation, appeared to adopt what was said in his police statement, "Am I still meeting you?" as being what Miss Burgess said. But Mr. Pierre also added that, to him at least, that and "Are you still coming over?" mean the same thing. I don't understand what the relevance of what it meant to Mr. Pierre was. The question was what those words meant to a jury. And those words, "Are you still coming over?" are very different from anything which suggests that there was an arrangement to meet at 10 Derwent Lane. And that is the crux of the Crown's case. His lordship continued. He said he did not recall Miss Burgess saying, "Call me when you're up the road. I'll be at my job." Ultimately, as I say, it's a matter for you to consider, ladies and gentlemen, what you accept was said during that conversation and what is the significance of what was said. Remembering always that the burden is upon the prosecution to prove the guilt of the defendant beyond reasonable doubt, so that you feel sure. Now, his lordship also goes on at line 20. Sorry, let's go to line 15. Remember also my direction to you as to what that you can put to the direct evidence of this telephone call, which seems to confirm intention on both the part of Mr. Gibbons and Miss Burgess to meet, which is not necessarily an issue, but your lordships will be alive to the fact that the central thing that is an issue is where they were supposed to meet. Because unless the evidence rises to proof of the fact that Miss Burgess actually intended to meet him at 10 Derwent Lane, that's a gaping hole in the Crown's case. It's in fact the only admissible evidence they rely on to sustain a conviction against her, as I'll demonstrate. And on this point, Mr. Pierre, his evidence taken at his highest was completely unhelpful. Because as his lordship goes on to say, in fact, even if Mr. Gibbons had said, "Oh yeah, I'm gonna meet her at 10 Derwent Lane," which is not the evidence, that's not the evidence that Mr. Pierre gives of what he heard Miss Burgess say. Even if he had said that, as lordship goes on to say, I think it's agreeing between the defense for Miss Burgess and the prosecution that there was an intention to meet. The question, as I've said to you before, ladies and gentlemen, is where that meeting was intended to take place. Remember also the limited use which you can make of the evidence of what Marcus is supposed to have said to the Pierres about his understanding of where that meeting was to take place, which is evidence of Marcus's state of mind only, and no evidence against Miss Burgess. So in the final analysis, all of this conjecture about what Mr. Gibbons thought where he thought he was going is of no value to the Crown, because it's evidence of his state of mind only and of no evidence against Miss Burgess. And no inference can be drawn about her state of mind from his. So that's putting that part of the Pierre's evidence in a box. And in fact, Mrs. Pierre falls into the same category. And I won't take you to her evidence because essentially the thrust of it, as the Crown relied on, was the same. That Marcus seems to have intimated to Miss Pierre that he intended to meet Katrina Burgess, according to her understanding, she says, and she expects she wasn't sure, at the apartment at Derwent Lane, although those words were never said.
Mr. Richardson, it would be helpful for me, at any rate, if you could just take us to the exact terms of what Mrs. Pierre said.
My lord, I think you'll find the first two, volume one, the first two witnesses are sorry.
I didn't hear the start. I think if you
When
move
you
away from
move
the
to
mic.
a right, we
Sorry.
lose your voice.
Volume one, the first two witnesses are Michael Pierre and Michelle
Yes.
Mawson Pierre.
Right.
And my lord, what you'll find is that the evidence of Mr. Pierre goes on for some 90 pages. And I haven't marked the specific portions because I take the view and have relied on his lordship summing up is a correct analysis of what Mr. Pierre said in a nutshell. I don't disagree, and I don't think the Crown disagrees with how his lordship has characterized Mr. Pierre's evidence. Neither do we disagree
Right.
the way in which his lordship, in his summing up of the evidence, fully characterized the evidence of Michelle Pierre. But what I say to their lordships is this, that even if taken at its highest, Mr. Gibbons had actually said, which he didn't on either witness, I'm going to 10 Derwent Lane to meet Katrina because we have a prearranged meeting to meet there. That would not have been admissible against Ms. Burgess. It would have been of no evidential value in establishing the case against Ms. Burgess, as his lordship made it clear. It was evidence of his intention only, so it took the Crown nowhere.
Well, just a minute. If indeed Ms. Burgess said, "Are you still coming over?" wouldn't it be possible to draw an inference that coming over meant coming to Derwent Lane?
It is possible to draw that inference, but there was also evidence before the jury that her position was, and there was evidence that was extracted from cross-examination of police officers. No one will deny, his lordship references it in his summing up. There was clear evidence before the jury that her position was that he was to come and meet her at her job. So coming over on the evidence before the jury could have meant either one. I accept his lordship. That is a possible inference when she says, are you coming over? But that's not the only inference on the evidence. Clearly not the only inference.
This is a call just before 8 o'clock at night, so she wouldn't typically be at her job at 8 o'clock at night.
Well, no, my lord, that's not the evidence either. There is evidence that she did occasionally work late. That comes from Mario Rialjo, the cleaner.
Right, but very well.
So that it wouldn't be correct to say that. And in any event, my lord, the analysis that you're pursuing would not on any good day exclude the other inference that coming over means exactly what she says it did. And we have to factor into that another ground we're going to pursue, which is the missing voice note or missing voicemail.
Well, no doubt we'll come to that.
Yes, my lord. So that's what I say about that limb, which with respect to the Pierre's evidence, that it has to be put into that neat box. What does emerge from the Pierre's evidence, as my Lord Justice Bell has identified, which I say can be used, is that utterance by Miss Burgess, which was the only one that Mr. Pierre seems to have clearly heard, which doesn't take the Crown anywhere near establishing that there was a meeting at Derwent Lane planned. And in any event, it's not any evidence of her intention to meet there. That's not what she said. My lord, the final
just for the record, Mr. Richardson, where Mr. Pierre says that Miss Burgess said to him, "Are you still coming over?" I have that at the bottom of page 23, top of page 24. And then you cross-examine him on the particular words.
Yes. Yes.
Yes.
Yes, my lord. I would commend you to have a look at that, and you will see that his lordship definitely summed up that part of the evidence fairly accurately.
Right.
And he did the same with Miss Pierre, and we submit that he correctly put that part of the Pierre's evidence in the correct category, evidence of his state of mind. and not of Miss Burgess, and of no use in the case against Miss Burgess other than background evidence. The final limb, my lord, if I could move on. The final limb of the prosecution's case against—
Well, just a moment before, sorry, if you go back to page 154,
Yes, my lord.
The judge says at 7, the evidence of what Mr. Gibbings is supposed to have said to the Pierres is not evidence of Miss Burgess' intent or evidence that there was an arrangement to meet made between them at 10 Derwent Lane, whether or not Miss Burgess ever intended to keep that appointment. There was, of course, other evidence from Vernon Charles.
I'm about to move on to that next.
You're about to move on to that. I'm so sorry.
Yes, I am.
Right, okay.
I'm about to move on to the evidence of Mr. Charles next.
Oh, okay.
And what we say in paragraph 12 is that the final limb of the prosecution's case against Miss Burgess was in relation to statements made after Mr. Gibbons' murder to individuals, including Vernon Charles and the deceased mother, Miss Sandra Ferreira. Our position is that, taken at its absolute highest, my lords, the evidence of Vernon Charles was that the appellant Burgess had told him approximately 1 year after the murder that she was to meet the deceased at home, which the prosecution invited the jury to accept meant 10 Derwent Lane, and that she, the appellant Burgess, proffered an alternative theory on the deceased murder, namely that 2 men from Trinidad had killed him. The prosecution advanced the case that the appellant Burgess had lied out of a consciousness of guilt when she postulated the alternative theory on the murder. He actually ended up rejecting his evidence in chief, my lords, the adopted contents of his statement, but I'll take you to his evidence because it is important. In paragraph 14, we submit that the evidence of Vernon Charles can be taken no higher than this. He was told by the appellant Burgess approximately 1 year after the murder that she was to meet the deceased at the apartment, and she informed him that she had received information surrounding the killing that suggested 2 men from Trinidad committed the murder. And you'll see that she actually did inform Mr. Charles that she received that information from the police. And I'll take you now to Mr. Charles's evidence, which I believe is in volume 2 at tab 15. And
Mr. Richardson, I'm sorry to interrupt you, but I'm just looking at Mrs. Pierre's evidence, and she's gone into a lot more detail in terms of what she actually said, looking at page 18 of tab 2 of the transcript.
yes, my lord, she does go into more detail, and she actually claims that Marcus told her he was going to Derwent Lane. But my lord, I remind you that even if, taken at its highest,
Even if that was said,
that was of his intent only, and there was no use against Miss Burgess. And that deals with that conclusively. As I said in my submission, she could have actually—
she said what Mrs. Pierre said in terms at page 18 was that she wanted to talk to him about things. Well, this was speculation on her part, I agree. Odds and ends that were left in the apartment.
Yes.
Just help me on this. If it's agreed that there was an intention to meet up somewhere, and Marcus in fact went to the apartment, would that be evidence on which it would be open to the jury to conclude that the arrangement was that they would meet at the place to which he went?
Lords, I would say no, because there's evidence from the woman he was having an affair with that he was actually at the same time at the Pierre's having a 40-minute call with her in which he was arranging to try and meet her.
Right.
Tab 15, Lords. Sorry.
Maybe he was, but he went to the apartment.
Yes, he did go to the apartment, but we don't know where he was arranging to try and meet her. That is Miss Trott, formerly Hunt.
Right.
She doesn't say that in her evidence. She just says that he was trying to get her to come and meet her either at the Loy Ho apartment, I think was her assumption. But I do take their lordship's point, the fact that he went to Derwent Lane, one inference can be that he went there because he was to meet with someone. The other inference could be that he went there simply because he still had belongings in the house and just simply went there. If I could take you to, it's tab 15. The early stages of his evidence are not controversial. But when we get to the part about the memorial service, that is the part that is very important, because that is the part that the Crown rely on as an admission by Miss Burgess that she arranged to meet him at Derwent Lane.
Yeah.
And it begins on page 24. At line 3, I'll begin. At what time was the service? 4 o'clock. When you got there, did you do anything? I started making my way into the church. Yes. And then I met Katrina. Where? At the step of the church. Do you see her in here? Yes. Where? Over there, sir. Okay, so you said met her on the step of the church. Yes, sir. Was she alone at that time? No, sir. Who was she with? She was with another lady. And she said she was staying with this person. Okay, so when you met Miss Burgess on the step of the church, what happened? We hugged. We hugged, yeah. Yes. And she started to talk to me, yes. She said that she's supposed to, she called Marcus to meet him at the apartment. Yes. She was going to Blue Dragon. She was going to Blue Dragon to get some food, and then she was going to meet Marcus. Yes. And after that, she said that 2 guys came from Trinidad. Sorry. After that, she said 2 guys came from Trinidad to kill Marcus. Sorry, my lord. And there was an objection by me, and the evidence then continued. Yes, Mr. Mooney. Okay, you're still under oath. Yes, sir. So did she say anything else after that? No, I cut the conversation short. Okay, incidentally, when she was talking to you, was there anyone else in your immediate vicinity? No. Where was the other lady? The other lady walked off. Okay, no further questions. And Mr. Daniels had no questions. Now, when I cross-examined Mr. Charles, I began by asking him about his recollection of things that took place 13 years ago, because that's essentially what he was being called to give evidence of. A conversation that took place 13 years prior, on which the exact recollection of what was said was going to be crucial, because it was the only admissible plank in the Crown's case to prove the assertion that Miss Burgess lured Marcus Gibbings to 10 Derwent Lane. And his lordship identifies it as such in the summing up. So he says that dates he begins at line 19 are things that he might have some difficulty with. Okay, so some of the exact details are not that clear. What happened? That I know. Yes, was clear. The actual date? A little fuzzy. Like, all right, let's see how clear you were about some things. You said in your evidence in chief, I noticed it, that when you described the incident that apparently happened at, I think it was around 11 at night, you got a call from Marcus. He said, yes. You actually said this was about in August. And then he said October, and then you said October. And then you said, no, it was October 2006. Remember that? Yeah. But why am I saying that? Because it was cold. I know that for sure. Because when he called me down there, I said, yo, why you have me down here by this Detroit school? I'm from Trinidad. I'm not accustomed with the cold. Right? I got you. So I wanted to get out of that. I wouldn't really be cold in August, though, would it? It was cold to me, not for you. So again, he's describing being cold. I'm testing his recollection, and the entirety of his evidence, taken as a whole, you'll see, is unsatisfactory. You're saying it was October, though. So was it October or August? Because you said both in your evidence in chief. Because you really can't recall, can you? I can't. I know he called me. I can't remember the exact day, as I said. I can't remember if it's near the end of the year. I know it was cool. Okay, was it near the end of the year, the beginning of the year? No, not. It was, yeah, could be the end of the year. End of the year, not beginning of the year. Okay, but didn't you tell the police in a statement back in 2006 that it was early in 2006? No, I didn't. I can't remember saying early. Do you have the police statement? Let's have a look at it. Can the witness be shown a statement, page 243? And if you could ask him to be shown the last paragraph on the first page, Mr. Mahoney interjects, he has to identify the statement. He eventually looked at the statement and identified it. If you could direct him to the last paragraph that begins, I recall early in 2006, Marcus called me. I had to tell him, then don't read it out. You just read it to yourself, the last paragraph. I'm going to suggest to you, and you can confirm whether or not you told the police. Well, first of all, is that your statement? Yes, sir. And you gave the statement on the 4th of November. Yes, sir. That would have been what, 2 days after the memorial service? Yes. Okay, you told the police then that it was early in 2006 that he called you, told you to come to the house, right? Well, this is what it have here. Yes, sir. That's what is there. Are you saying you didn't tell the police that? What it say, I said early in 2006, Marcus called me. Yes, yeah, and I'm getting you to confirm, please. Yes, sir. Did you tell the police that? He eventually confirmed he told the police that. So when you told the jury here today, it was August or October. Which one is it? All I remember, sir, was cool. That is what I remember because I wanted to get out of the code. Question, January, February, a little chilly in Bermuda, isn't it? Yes. Could it have been then? And he says, no, wasn't then. No? Okay, so it wasn't early 2006. You're sure it was October 2006? You're not, are you? And so you're trying to tie this whole thing up. I must admit at that stage, the witness did get a little frustrated. I'm not tying it up. I'm comparing what you said in court with what you said 13 years ago. All right, sir. And what you said 13 years ago, I'm going to suggest to you is early October. You've come to court today and said October 2006. That's not early, sorry, early 2006. That's two difference. And he accepted it. Yes, all right. And I'm asking you, can you really recall which one it is? Or you're not sure, are you? I can't remember, sir. I didn't think so. You also told us, and just let me get it right, I think the way you gave your evidence, it came out like this. You gave evidence of a situation, this situation at Derwent Lane, when 2 guys showed up. And then you said, and I'm not going to take you painstakingly through that, but essentially, my lords, if you look at what happened, there was an incident in which 2 men came to the house, and Mr. Charles chronologically got the description of when that happened wrong. The important part, my lord, if I'll take you now to page 36. And if one looks a little further on, actually, beg your indulgence. Right, if I'll take you now to page 40. And the background to this is that when he gave, page 39 will give you the background, he gave evidence that when he last saw Marcus, or on one occasion he saw Marcus, he was living at Whitegate Lane. But in fact, when confronted with his statement, he realized that he'd gotten that wrong. And at the time of the incidents, he was actually living at Daisy Field Drive, which was put forth as another demonstration of the frailty of his recollection. Then, my lords, if you'll go on, and it is at page, beg your indulgence. If you look at page 42, I go back to the memorial service. And at line 10, I say to him, okay, and on that occasion, you did bump into Miss Burgess and you had a conversation. He says, yes, sir. And I think you already said she wasn't alone. No, she wasn't. Who was she with? A other lady was in her presence, was his evidence. Another lady was in her presence? Yes, sir. So tell me about that lady. She said she was living with this person. And what did the lady look like? Describe her to me. Female, whitish color. Whitish color, that's all you can remember at this stage? What's that? Is that all you can remember at this stage? Oh, yes, sir, because my mind was on something. My mind wasn't on who she was with, or I was just trying to get to the memorial service. Memorial service, yes, sir. Okay, your mind was also on how attractive this lady was who was with her. And that line of questioning was meant to demonstrate to him that he really wasn't paying attention. He says, which is just the person to come up with her. And I just had a glimpse. And like I say, you had a glimpse? You took such notice of how attractive she was that you actually told the police. Yeah, you know, good looking girl, man, show the link. Yeah, well, that's like a first catch, like that's a glimpse. It wasn't nothing to me. No, I'm not saying it wasn't anything to you, sir. You're a man, you're human. I'm not criticizing. Yes, all right, okay. So here's the important part. At line 8, can he have the statement taken from him in front of him now? Because I don't want him reading while I'm doing this, because I'm about to come to an important part. And I said to him, I think in your evidence in chief is, hold on a second, you said Katrina you hugged. She started to talk to you. She said she called Marcus to meet him at the apartment. Are you sure those are the words she used? He says, yes, sir. Question, you're sure those are the exact words she used? This is very important. If you can't remember the exact words, be honest, sir. I'm trying to be as honest as possible. Are you sure those are the exact words she used? The apartment. That's what she said to me. So I've given him 3 or 4 different occasions to confirm that that's his recollection. Yes, those are the words she used. I'm sure of it. Okay, but I'm going to suggest to you that in 2006, you told the police she said home. She never used the word apartment. Have a look at your statement. I'll take you to it. I'm not going to lead you astray. And I asked, can he be shown page 245? And if he could look at it. And if we could actually do a system and direct him, and he gets the statement. Okay, I'm going to suggest to you that what you told the police back in 2006 is that she said that she would meet him at home. Not talking about the apartment. That's what you said she said. His answer was, well, the apartment is where they're living in, sir. That was his answer. Okay, well, what did you say back to the police then? Home or apartment? I said, that's on my statement, is what I said. And your statement says whom? And he answered, yes, whom? Right, but today in evidence in chief, you said apartment. Well, it's still the same. Whom? That was his opinion, which carried them nowhere. I need to know exactly what you heard her say. And you can't remember the exact words you heard her say. Answer, you're straying what I'm saying. Be honest. This is what I said here, sir. I said, which one? The one in the statement, or the one in court? And Mr. Mahoney, sir, you see, I'm having a problem as the witness starts to talk, because at this point, the witness and I were going back and forth. And the court says, let him answer your question. Okay, I'll let him answer. So I would just ask the question again to be clear. He says, yes, sir. Which one are you sure you heard? At whom, as written in the statement, or at the apartment, as you said in evidence in chief? At whom, sir? This is what I said to, that's what you said. Is that what you said back then? Or is that what you're saying now? This, what was said to me, sir. Sorry. This what I remember said to me. Okay. Do you understand what I'm asking, sir? Yes, sir. You said apartment today, but 13 years ago, you said home. Yes, sir. Okay, I'm asking you because it's very important. Do you remember the exact, because that's 2 different things. Do you remember the exact words, or are you paraphrasing? I remember. This is what my conversation was told to the police when she said she would call him to meet her at home. At home? Yes, sir. Okay, I'm going to suggest to you that she never told you she was going to meet him at home. She said she was going to meet him at her job. Well, that's what you're saying, sir. Okay, well, are you sure what was said? Because you've given us 2 different words, apartment and home. All right, sir. How long did this conversation take? And he says, like about 15 minutes. 15 minutes. And that's all that was said in 15 minutes. Well, I didn't go exact word for word. And okay, well, but if 15, this part here, that she told you what you said in evidence, that she told you she was going to meet up with him at the apartment, or whom, whichever one it is, we ain't sure. And then she said she was going, I think, where is it to? And he says, Blue Dragon. Go and get some food and then go to meet Marcus. That couldn't have taken 15 minutes. Can you remember word for word the other parts of the conversation? Or was it just this part you remember? He says, no, sir, I can't remember everything else at that part. That you remember that all the conversation. I remember this is what she was saying to me. Okay, all right. Did she tell you where she was going to get something to eat? She said Blue Dragon. Okay, I'm going to suggest to you she told you Lobster Pot. Yeah, you could say, they could say that. I know what I heard. Okay, and when did you give this statement? And if you'll go on, my lords, over to page 51. There's an exchange where I say at line 11, yeah, but you remember a conversation word for word. You can tell us 2 days later after memorial service to tell the police. Release that your evidence. And the build-up to that is that I asked him whether he took a note of what was said. It begins at page 50, after the memorial service. He says no. And then he goes to the police 2 days later and claims to recall the conversation word for word. Well, that part of the conversation, nothing else. I then go on. If you look at page 53, line, where is it now? Yes, page 51. Line 17, where the question is asked. There's this issue. You've said to us that 2 guys came from Trinidad and killed Marcus. Remember saying that to this jury? Yes, sir. She said that, or she told you, did she say that is the question? Because his evidence in chief was that she told him that. And I asked him, did she say that? Or did she tell you that a police officer told her that? And he says, she said that to me, sir. Did she tell you that she said that to me? He repeats. The question is, she didn't tell you the police said that to her? She didn't say the police, and I said to him, are you sure? Sir, she said it to me. I didn't say it to her. She said, I'm sure that you didn't say, that she didn't say to you that, I'm sure that you didn't say, that she didn't say to the police, say to you, the police told her that. She said, 2 guys from Trinidad came to kill Marcus. Question, you're sure you recall those words exactly? That's why I stopped the conversation. This is just another example of where he swears. He recalls words exactly. And here we're talking about a difference between the words of apartment, home, and job that the Crown are hanging their hat on for a conviction based on the recollection of a man who's all over the place about events that took place 13 years ago. He goes on, okay, and said, I don't want to do this anymore. Okay, leave it for the police. Let me ask you are you sure those are the exact words she said? Yes, sir, that's what I remember, sir. Question, didn't mention the police telling her? Answer, I didn't remember anything what the police said. Okay, are you as sure about that as you are about her saying that she was meeting him at home, the apartment, Blue Dragon? Are you as sure about that as you are about the others? I'm trying to remember as best as my recollection, sir. Well, let me help you. Let me take you your statement again. Same page 45. We're going to go over what you just said. You're sure you said. If you look at that same paragraph I asked you to read, yes, sir. And it's strange because you just got to read it. Bottom, you said, she later stated that the police told her someone from Trinidad came and killed Marcus. You see, you said that in 2006. Yes, sir. Okay, you don't recall saying that? Because you just adamantly denied over and over to this jury that you would have said that. And I asked you how right you are about that. Are you as right as you are about the other stuff? Remember that? Yes, sir. You do now accept that you were wrong, don't you? Yes, sir. And of course, Mr. Mahoney says wrong about what? And I said wrong about what I just asked him. And I'm going to suggest to you, you could be just as wrong about the other parts of the conversation, no matter how stridently you say you're sure. Mr. Mahoney, sorry. Will the witness be allowed to answer? Would you just repeat your question again? I'm going to suggest to you, well, we can see you were wrong about that. Yes, sir. That you're just as wrong about the details of the conversation you had at the memorial service, no matter how confidently you may say you are. Well, I know this happened. Sure, a conversation happened. It's 13 years ago. And I'm suggesting you don't remember word for word the things you discussed. You are paraphrasing, sir. He says, okay. I say, okay. It seemed to me like he was accepting it. One more thing. The night that you went to the house with Marcus, that is, again, me returning to the men walking around the car. And that's an incident he described where he tried to give the impression that Marcus was outside banging together and Miss Burgess was inside, but he eventually conceded, page 56, thereabouts, that he doesn't even know if she was inside. So that's the totality by the looks of it. And a re-examination, just to be fair, Mr. Mahoney re-examined him. And on the issue of the utterances she's supposed to have made, I think you'll find that on page 59, starting at line 20. And he explains, this is what happened. This is this. This is I and the young lady Katrina is having a conversation. And if this is what was said, I just have things in my head. It's a lot. It's a lot of years going by. And I remember basically what was said to me, like, that's why I stopped the conversation at that particular point, because I didn't want to go any further. And even in re-examination, he's a long way away from being certain that those were the words that were spoken. But that, according to his lordship, is probably the highest point of the Crown's case. If I could move on, sketching out the factual background now, my lord, to just deal with paragraph 14. There's a subparagraph, and it moves on to the evidence of Miss Sandra Ferreira, who is the deceased mother. And we say that that evidence is respectfully of no real substantive value to the case against the appellant, and that it amounts to the appellant Burgess, yet again, on the prosecution's case, positing another theory on the murder, namely that it could potentially have been a robbery. The prosecution advanced the case that this was another lie by the appellant Burgess, made out of a consciousness of guilt, with the intention of deflecting attention away from herself. Even if, it's our submission, this honorable court accepts that it was open for the jury to conclude that the evidence of Sandra Ferreira demonstrated that the appellant Burgess had lied, which of course is denied, this did not advance the prosecution's case one iota, insofar as it did not establish any element as a matter of law of the offense of premeditated murder. Now at this stage, just to round off things, my lords, I think I should refer you to the way in which my lord, his lordship, characterized the evidence of Vernon Charles when he summed up to the jury. Just find the reference. I think it's on page 214 of the summing up, which is volume 3.
Yeah.
And it begins at line 5. That's the court summation, but let me take you first to the way in which his lordship dealt with in the no case submission. That's where I meant to take you. And that is at page 16 of the same volume. And at line 20 on page 16, his lordship says, turning now to Ms. Burgess, the prosecution case against Ms. Burgess pursuant to section 27(1)(b) and 27(1)(c) is limited to her doing an act for the purpose of aiding or enabling another to commit the offense, or in fact, aiding another to commit the offense. That case is based upon the direct evidence of Vernon Charles, who said in evidence in chief that she called Marcus to meet him at the apartment. She was going to Blue Dragon to get food, and then she was going to meet Marcus. In cross-examination, Mr. Charles adopted what he initially told the police in his November 2006 statement, that Ms. Burgess had said she was to meet Marcus at home and not the apartment. And when challenged by Mr. Richardson on the differing versions, Vernon Charles stated that the apartment is where they live, so it's still the same, home, which is a very evasive answer. He did not accept the suggestion that Ms. Burgess told him they were to meet at her job. Taken at its highest, Vernon Charles' evidence is an apparent admission by Ms. Burgess that she called Marcus to arrange to meet him at their former Derwent Lane home or apartment, which the prosecution are asking the jury to infer from other circumstantial evidence she never had any intention to do. So adding that to the circumstantial evidence of, among other things, motive, the timing of her telephone calls on the evening in question, the combination of evidence of her alleged concocted alibi, if I can call it that, involving Vernell Kane seeking out and engaging the cleaner at Seaboard Overseas, the telephone call and subsequent visit to Lobster Pot, together with their comments or intentional lies spoken out of the consciousness of guilt, as the prosecution would say, after the fact, aimed at, it is said, deflecting attention from herself, which she made to both Ms. Ferreira and once again Mr. Charles. And it is submitted by Mr. Mahoney that the evidence against Ms. Burgess, taken as a whole, is such that a reasonable jury could, on one possible view of the evidence, reject all realistic possibilities consisting with innocence, and so reach the adverse inference, citing Archibald 4365, referencing R versus G and F. The test being whether a reasonable jury, not all reasonable juries, could, on one possible view of the evidence, be entitled to reach the adverse inference. And he goes on to find, basically, on the basis of Mr. Charles's evidence, in combination with other evidence which we have already submitted, did not carry the Crown's case any further except by way of background evidence and motive, to find that there's a case to answer. The next significant portion, my lords, is the way he deals with it when summing up to the jury. That is at, begins at page 214. At line 5, and his lordship, he deals with the evidence of Miss Ferreira, it seems, and on page 230, he says, now before again moving on to the investigation, which I said I was going to do, let me just here deal with the evidence of what Vernon Charles says take place at the memorial service for Marcus. And after that, I'll deal also, I think, with the evidence of Marcus's mother, Miss Ferreira. Vernon Charles said that he arrived early for the memorial service, and he stated that he made his way into the church. He met Miss Burgess on the steps. He said that she was with a lady friend with whom she indicated she was staying at the time. Mr. Charles said that they hugged, and Miss Burgess began to talk to him. He said that Miss Burgess told him that she had called Marcus to meet him at the apartment. She was going to Blue Dragon to get some food, she said, and then she was going to meet Marcus. After that, she said that 2 guys came from Trinidad to kill Marcus. He said that no one was in her immediate vicinity as she was telling him this, because the other lady had walked off, and that he then cut the conversation short. Mr. Charles was then cross-examined by Mr. Richardson for Miss Burgess, and he initially confirmed that Miss Burgess told him that she called Marcus to meet him at the apartment. But Mr. Charles was then shown his 2006 statement and confirmed that what he told the police in that statement, and he confirmed that he told them that Miss Burgess told him she would meet Marcus at home and not the apartment. But Mr. Charles added that the apartment was where they lived. So it was really the same thing. The apartment was still home, he said, and that was his attempt to avoid evasively the inconsistency. Mr. Charles adopted as his evidence what he told the police at the time back in 2006, which he confirmed that Miss Burgess had said home to him and not the apartment. He also said in re-examination that even though a lot of years had passed, he was able to basically recall what she said to him, and that and that's why he said at the time he stopped the conversation with Miss Burgess, because he didn't want to get into it any further. Mr. Charles did not accept Mr. Richardson's suggestion that Miss Burgess told him that she was to meet at her job. It was never suggested to him that Miss Burgess said down the road, and I corrected that effort at Mr. Richardson's closing address earlier. Now, as Mr. Richardson himself acknowledged to Mr. Charles during cross-examination, this is very important evidence, because this is very important evidence because, ladies and gentlemen, it is, as you will no doubt appreciate, the only direct evidence capable of supporting the prosecution's contention that Miss Burgess had arranged to meet Marcus at the Derwent Lane apartment. Because as you will no doubt recall, the other evidence you have heard about where they were to meet, if you accept it, merely established that it was Marcus's understanding that he was going to meet Miss Burgess at Derwent Lane. It was no evidence that she had actually agreed to meet him there. This evidence, however, from Mr. Charles, that Miss Burgess told him that she called Marcus to meet him at home, is the only evidence which speaks to Miss Burgess herself arranging to meet with Marcus at Derwent Lane. And as I say, that is capable of supporting the prosecution's contention, if you accept it, which is entirely a matter for you. The prosecution say that this is evidence that Miss Burgess lured Marcus Gibbons to the Derwent Lane apartment. And they further say that the reason she did this was because she knew that Mr. Rogers would be waiting for him there to kill him. Now, there's a difficulty with that, which we will return to later, because in that sentence, his lordship has confronted what I call the tangle that can't be untangled. And if you look at what he said there, he's basically said the prosecution say that this is evidence that Miss Burgess lured Marcus Gibbings to the Derwent Lane apartment. That essentially was the crux of their case against her on the admissible evidence. And they didn't even make that out. And they further say that the reason she did this was because she knew that Mr. Rogers would be waiting there to kill him. How and where would that evidence come from on a case admissible against her? That is the tangle that cannot be untangled.
Mr.
And
Richard,
throughout, yes, my lord.
I just ask you this? I mean, plainly, anything that Rogers said to the two confession witnesses, if I can call them that,
Yes, sir.
is not admissible against your client. If the jury were to conclude that Rogers was in fact the killer,
Yes, sir.
is that fact, once it becomes such, admissible against your client?
My lord, I think you're referring to the process adopted in the case of Hayter. And what you'll find, my lords, is that in this case, we had extensive discussions about that case, and his lordship specifically steered away from directing the jury in that way. And that's very evident from the summing up. Yes, that route could have been adopted, but both the prosecution and the court did not wish to adopt that route. None of us wanted to.
Where there's an allegation of joint offenders,
Yes,
I mean, it's something that was born out of conspiracy, but it doesn't have to be conspiracy. Any joint offenders.
Yes, my lord.
What one says in the absence of another isn't admissible against the other. But what one does allegedly in the course of the joint offence is, isn't it?
Yes, my lord, what one does, but that's not what we are discussing here. Here, there isn't anything that I can see of any significance that Miss Burgess done, except on the Crown's case, the luring. But the luring only takes you so far, as his lordship subconsciously recognized in that passage that I'm reading now at line 19, where he begins the prosecution say that this is evidence that Miss Burgess lured Marcus Gibbings to the Derwent Lane apartment. That is the evidence that is available to them, admissible against Miss Burgess on this case. This next part, and they further say that the reason that she did this was because she knew that Mr. Rogers would be waiting for him there to kill him. That only emerges from the inadmissible evidence that was given against Mr. Rogers. That part of the story cannot really be told against her. But throughout the entire case, everyone's conflated the two. It's a tangle that can't be untangled. If I use a fishing analogy, sometimes you can untangle the line and you can keep fishing. Sometimes you have to cut the tangle out because it simply can't be undone. And on the facts of this case, we say this was a case in which the tangle could not be undone, no matter how.
Let's say for the moment that the evidence against Rogers was not one of confession, but was DNA.
Yes, my lord.
If the jury came to the conclusion that as a result of the DNA evidence, he was the killer.
Yes, my lord.
The consideration of the case against your client could include consideration of that fact, couldn't it? I know you say that's not the way the judge was putting it, but
I follow what his lordship's saying. In a DNA case, as his lordship has just postulated, yes, that route could have been taken, where if the jury was satisfied that defendant A was guilty based on the DNA evidence and evidence that was admissible against him, they could then use the fact that they think he is guilty as but one consideration in determining whether the subsequent defendant is guilty. However, the difference between the DNA evidence and the confession evidence is that the DNA evidence typically would tie that defendant against whom it is being used to the crime alone. In this case, this so-called confession tied my client to it, specifically named her and mentioned her, and specifically set out what the intention was.
That's a different matter.
Yes, and I agree, my lord. That's the point. That is the distinction
With
between
the
the
DNA, with the DNA evidence, that would be admissible against your client because it doesn't consist of a confession made to somebody out of court. It consists of somebody actually performing an analysis of DNA found at the scene and comparing it with the DNA of, in this case, Mr. Rogers, and that's
Yes, my lord.
against the world. So
Well,
if you, isn't it?
My lord, what I would say is that it would be admissible in the case as a whole.
Yeah.
But strictly speaking, when a judge comes to direct a jury, he wouldn't be directing a jury that you could use the DNA evidence against the co-defendant. What he would say and put in the proper box is that the DNA evidence establishes A, B, and C, and you're entitled to reach certain conclusions about whether defendant A was the killer. But it doesn't take you any further with respect to defendant B.
Well, wait a moment. That may not necessarily be so. If there were DNA evidence and it were to establish that Mr. Rogers was the killer,
yes,
that would self-evidently mean that Marcus was killed by Rogers at the apartment.
yes,
If you marry that with evidence which, if accepted, is said to show that Burgess arranged for Rogers to go to the apartment, there would be evidence that a murder had been carried out because it had been carried out by Rogers, and there would be evidence from which the jury could conclude that it had all been set up via Burgess.
my lord. Sorry, my lord.
No, that's right, isn't it?
No, my lord, I don't agree with the conclusions that my lord reaches on that.
What's wrong with them?
The case that we're considering here is not a DNA case, first and foremost.
I know. This is, I think, a point in your favor. Just listen carefully.
Yes.
If there was DNA evidence, that would show that Rogers had committed the murder.
Yes.
And it would seem to me that it could be said that if it had been arranged that the victim should be where Rogers went and murdered him, that is evidence that Burgess was part of the plan to murder him. The problem for the Crown in this case could be said to be that there isn't any DNA evidence. The only evidence that Rogers murdered Marcus is the confessions made by him.
Yes.
And those confessions are only admissible against him.
Yes. Yes, my lord.
Yeah. That's what I think you would say.
Well, there's another point that should be taken into account, that there's no evidence that Miss Burgess arranged for anyone to be in that apartment that night. That's another point. But I take the point his lordship is making. But the essential crux of our submissions is this, my lord. I think what you're saying, the difference between this case, as you've basically outlined, is that in this case, the confession evidence is the only evidence that Mr. Rogers is the killer. And that evidence is not admissible against her. That is a gaping hole that the Crown could not deal with and still haven't dealt with. But it's worse than that. Because as we'll develop later in our submissions, even if it is accepted that she may have arranged to meet him at Derwent Lane, and we say the evidence doesn't nearly rise that high, especially when one properly directs themselves on the inferences that can be drawn, we say that even if it can be shown that she arranged to meet him at Derwent Lane, there is no evidence that she arranged to meet him with the intent that he should be killed. And that is the only intent that will do. Nothing else will suffice. The Crown did not leave any other alternative. So where is the evidence that there was an arrangement to kill him? As we point out on our submissions later, what if the arrangement was, and we don't say it was, but there's evidence here that what if the arrangement was to have him meet there and have a talk with him? Tell him about himself. Tell him to ship up or shape out, and things got out of control, and she wasn't aware of that. Then in no way would she be guilty of premeditated murder, which is the only charge on the indictment. And there's no evidence of premeditation for murder on her behalf, except the very loose inference, which I say is speculation, and I make it out later in the submissions, that in fact, there is evidence from which that intent can be derived.
If the jury are as finding that there was an arrangement to meet, but she in fact didn't turn up,
Yes,
which is the fact,
yes,
but her brother did, and we now know the jury was satisfied that he did and committed a murder. Is the fact of her non-attendance relevant?
the fact of her non-attendance, my lord, might be relevant in the sense that it would allow the Crown to say what it did say, that she arranged to meet him there and had no intention of being there, but it does not in any way address the issues I've just raised. It still doesn't cross that chasm. If that is meant to be a bridge, then it falls into the canyon. It doesn't cross the threshold of demonstrating the mental element on her behalf of premeditated murder. Because even if I were to give the Crown the benefit of every doubt on the admissible evidence, the highest that this could be taken, and I don't give them all of that credit, as you can clearly see, is that she might have arranged or did arrange to meet him at Derwent Lane, and her brother was going to be there. What was going to happen at that time? There's no evidence that she had any previous knowledge, whether there was going to be a fight, a discussion.
What the jury is entitled to infer is that, having found that Rogers did attend and did kill Marcus, that if they get as far as finding that that was as a result of an arrangement made with your client,
Yes, sir.
why should they not infer that what he did was what they had agreed should be done, in the absence of any evidence that they'd agreed something different?
Because on his lordship's own analysis, with the greatest of respect, you've asked for an inference to be drawn from an inference. The first inference, that there was an arrangement, is one thing. What the details of that arrangement were, i.e., whether to simply do some harm or to kill, are of crucial distinction in a case like this, where the defendant is charged with premeditated murder. So again, my lord, with the greatest of respect, I don't think that that particular analysis helps the Crown to cross the chasm. The canyon is still there. If his lordship understands what I mean, I don't see that helping them.
Plainly, I understand what you mean, but
If I could put it more clearly, the first step might be an inference. The second step, my lord, would be speculation, would be my submission. It would be simple guesswork to conclude that there was an arrangement to kill him and kill him alone. We are stretching with the greatest of respect. That is not an inference that is open to any reasonably directed jury on the evidence that was before it. On the admissible evidence. Now, here is where the tangle comes in, my lord. If the jury subconsciously factor in that Mr. Rogers is supposed to have confessed and said that the reason he was there was to kill Mr. Gibbings because he was being paid to do so, there the picture is complete. But you can't complete it in that way, not against Miss Burgess. And that is the error, the golden thread of misfortune, which has run through this entire case. The tangle that I say cannot be untangled and could not be untangled. There is no other explanation for the conviction of Miss Burgess. The other evidence against her was insufficient, as we will demonstrate. I think that is all I wanted to show you with respect to how the court characterized Mr. Charles's evidence at its highest. I think it was important for you to see that, because essentially those two limbs, the 7:51 telephone call, the evidence of Mr. Charles, are what the Crown rely on almost in totality to demonstrate that Miss Burgess lured, as they say, Mr. Gibbons to Derwent Lane. But that evidence by itself can hardly establish that fact, my lord. And it would be speculation to say that there was an arrangement to meet at Derwent Lane. To say that there was an arrangement to meet, I won't contest. At Derwent Lane is still an open question on the evidence, and it can't be answered by the simple fact that Marcus went there. He still had keys, he still had belongings there. He was still in the process of moving out on the evidence as well. We don't know why he went there. My lord, if I could now move on to the next section of my submissions. But before I do that, my lord, sorry. If I could ask you to address your mind very quickly to the factual scenario, because I don't want to have to revisit it twice, that has been sketched out by the Crown in its case for the respondent. The Crown follows the same format, advisedly. It's where they outline the facts that, as they say they are, in the initial parts of their. I have noted one or two things that I'd like to point out now before I go any further.
Right.
First is at paragraph, it's page 3 of the Crown's submissions, case for the respondent. And there's a paragraph 6, which begins, Donna Daly, the landlady of 10 Derwent Lane, stated that within a month after the appellant Burgess and Marcus moved to the lower apartment on the premises, there was an incident in which the appellant Burgess called her around 1 a.m. to come to the property. While Burgess was speaking to her, Marcus took up the bedroom phone and indicated he locked himself in the bedroom because Burgess was hitting off him, and he was scared of what she would do to him. Miss Daly went to the property shortly after and observed Marcus' things on the lawn, and the appellant Burgess looked very angry and trying to get into the bedroom where Marcus had locked himself in. When Miss Daly went to the bedroom window, she saw Marcus crouched down over in a corner inside the bedroom, and he looked terrified. When Marcus eventually came out of the room, he was observed to have a slightly swollen and busted lip. Now, the difficulty with that is that Miss Daly's statement was read in, my lords. And there was discussion about what could and couldn't be read in. And the caption "was hitting off him" was excluded, was not read to the jury. And if you look in his lordship summing up, he doesn't repeat it. The caption "crouched down in a corner inside the bedroom" was there, but he looked terrified. His lordship actually specifically directs the jury to ignore that because it popped out in evidence when it wasn't supposed to. And the evidence of him having a slightly swollen and busted lip never went before the jury. There was discussion and that was excluded. So to that extent, paragraph 6 is incorrect. The other factual issue that I did notice, beg your indulgence, is at page 8.
Sorry, was the jury, what about the slightly swollen and busted lip?
That evidence did not go before the jury, my lord.
Okay, right, thank you.
Page 8 is the next reference, my lord. And there's a paragraph that begins, when the cleaner went to her desk, she spoke to him about his daughter and personal stuff for about 20 minutes. Mario thought this was strange, as she had never spoken to him that long, and all the time he has worked there. Mario also found it strange that she was in the office at the same time, that she was in the office at that time, as he has never seen in the office late at night. If I could ask you, my lords, to look at the transcript of the evidence of Mario Jorge Rialjo.
Sorry, which page were you looking at a moment ago? Page
8 of the Crown's submissions, paragraph 21.
Oh, yes, I'm so sorry, yeah. Yes.
And the evidence of Mr. Rialjo goes on for some, not that long. And if I ask you to look at page 16 we'll begin at, my lord.
I'm sorry, which tab is he in?
We're in tab 9.
Tab 9, yes, sorry, my lord.
Yes.
And at the bottom of page 16, you'll see a question. What about Katrina? Did you speak to Katrina that evening? Yes, yes. I don't think, mumbling. Yes, when I go to clean Katrina's desk, she asked me about my daughters, about where I'm working before I worked, how many years I'm married, something like that. Question, personal things? Yes. Before that night, have you ever talked to Katrina about personal things before? I know. I don't remember. Can you remember how long you spoke to her about the personal things, your wife and all that? Good night? Yeah, how long? Maybe 20 minutes, 25. Before that night, had you ever talked to Katrina for that period of time, for 20 minutes? No. Before that evening, had you ever seen Katrina at Seaboard and you came in the evening to clean. And the interpreter said, he said, I've seen her many times. I've seen her many times before that in the evening. Question, in the evening, yeah? Okay, he's changed to sometimes he saw it in the evening, some of the time. Then how long before that night had you seen her there at the evening time? How long, how did you say how long before? Yes, yeah. When was the last time? Last time, months and months, interpreter months and months. Now, that characterization in my letter friend's submissions that Mr. Rialto said he found it strange, I haven't found that. I've never seen that. Mr. Rialto never said he thought it was strange. And he never said he found it strange that she was in the office late at night. He said what he said. He didn't assign any peculiarity to it. In fact, you might think he confirmed the defense case that, yeah, she does work sometimes late at night. Hasn't done it for a while, but she does do it. It's not as if she never does it. The other matters that my learned friend, I won't take issue with them, but those are the two that I thought I should correct.
Thank you.
The next section I'll move on to, my lords. My lords, may I ask, what time does the court usually break?
I was proposing that we should break at 4 o'clock English time, which would be 12 o'clock your time.
Oh, okay. We're used to judges taking a mid-morning break sometimes.
Yes, okay. Well, shall we have a short break now? I'm conscious that we've been going continuously.
That would be helpful because I'm about to move on to a fresh section, my lord.
Okay, well, let's have a 10-minute break.
Thank you.
Mr. Coelho, what do we do? Go into the waiting room or just remain as we are?
You can just turn your cameras and mics off.
Okay.
Thank you, Ms. Mulligan, for that reference. I'll see if I can get an answer when we come back.
And are we going into the breakout room, Mr. Coelho?
Yes. Is there anyone from corrections on the line?
Right.
Right. Yes, Mr. Richardson.
Yes, thank you, my lord. I left off, my lord, at paragraph 16, where I'll pick up. And
Right.
we have there the caption, what the prosecution had to prove
Yes.
against Burgess. The essence of the Crown's case against the appellant Burgess was limited to the allegation that she had done an act for the purpose of aiding or enabling her accused to commit the premeditated murder pursuant to sections 27(1)(b) and 27(1)(c) of the Criminal Code. Prosecution had to prove that the appellant Burgess planned and carried out with her co-accused, Cleveland Rogers, the offense of premeditated murder, and that she lured Marcus Gibbings to the 10 Derwent Lane apartment with the intention and knowing that he would be killed by Cleveland Rogers. And of course, the only evidence available of that last sting in the tail, knowing that he would be killed by Cleveland Rogers, the only evidence of that in the trial was admissible against Mr. Rogers alone. That is the confession. Again, the tangle that cannot be untangled. Paragraph 18, to discharge their burden of proof, the prosecution had to prove that all of the essential elements of premeditated murder as pleaded were present. First, the jury had to be satisfied that Cleveland Rogers had murdered the deceased. That's an essential fact. Secondly, the prosecution had to prove that the appellant, Ms. Burgess, either in some way assisted Mr. Rogers to unlawfully cause the death of the deceased with the intention formed before the stabbing and existing at the time of the stabbing to kill Marcus Gibbings, or that she did an act for the purpose of assisting or enabling Cleveland Rogers to unlawfully cause the death of Marcus Gibbings, and that when she did that act, she knew that Cleveland Rogers intended to unlawfully cause the death of Marcus Gibbings with the intention formed before the stabbing and existing at the time of the stabbing to kill Marcus Gibbings. We take the position that nothing short of that would suffice. Very simply put, my lords, the prosecution had to prove that Ms. Burgess arranged to meet the deceased at 10 Derwent Lane with the intention and knowledge that Cleveland Rogers would kill him upon his arrival. What the prosecution failed to prove. I think that's an accurate summary of what needed to be proved. In sum, my lords, we humbly submit that the following grounds of appeal will demonstrate that the admissible evidence against Ms. Burgess was incapable of supporting a conviction for premeditated murder, and the prosecution indirectly used inadmissible evidence insofar as it concerned the appellant Burgess, confession evidence, to bolster its weak and tenuous case against Ms. Burgess. And this is essentially one of our central contentions, because we say that when one properly parses out the inadmissible evidence from the case against Ms. Burgess, the remainder is clearly insufficient to safely convict. The paucity of admissible evidence, which the court was confronted with in respect of the appellant Burgess, we say, coupled with several regrettable errors on the part of the learned trial judge, resulted in the appellant Burgess suffering a serious miscarriage of justice. Now, my lords, you will have noticed that some of the grounds of appeal, I say dovetail. Some are relevant to others. The errors in one section have compounded or led to errors in another. The first ground we address is severance. And my lord, to return to the query that you made at the beginning of the hearing, with respect to severance, my understanding is that Mr. Coelho has now been provided with dates upon which the severance hearing likely did take place. And we have also clarified that it took place in the first week of the first trial in this matter. The first trial in this matter was mistried. That was the label given because the judge was unavailable for medical reasons.
And so what you'd said earlier, Mr. Richardson, was I think that the application had been made before the start of the trial.
The application had actually been made before the start of a previous trial, before a previous judge.
Yes, that's what I meant. But
Yes,
was it made before the start of the previous trial or at the beginning of the trial itself?
It was taken as a preliminary issue at the beginning of the previous trial, which eventually miscarried, my lord.
Yes.
We have now provided dates, and hopefully Mr. Cueto will be able to locate that on the court smart record.
Yeah.
I would ask their lordships to allow me to go ahead and argue the ground as it is conditionally.
But could you clarify for me, Mr. Richardson, whether or not this judge, Acting Justice Attridge, was even informed of what had happened before Justice Simmons?
The judge was aware that there had already been a severance argument. As I said, there was discussion about a practice in these courts by which one judge of the Supreme Court will not revisit the ruling of another judge of the same or concomitant level because they consider themselves to be sitting in appeal of each other. So for that reason, it was odious to even make the application before the present trial judge, because that is the position that was indicated would be taken.
Yes. I have a bit of a problem with that insofar as there would be all sorts of applications which might have been made before Justice Simmons, depending how far that trial had got. And one would expect that if you were starting a new trial, that you'd have to go through the exercise again.
Well, my lord, I would agree with you that that's the way we would have liked to have been.
Right.
But the situation we were confronted with is that we were informed of a practice, which is not the first time I've come up against this practice, whereby if a ruling has been made on an issue by a previous Supreme Court judge, asking a subsequent judge to revisit it is not met with great favor at all. So in essence, I was already of the view that if the severance issue was going to be taken again, it would have to be taken before your lordships if we got to that stage. And unfortunately, we are at that stage. So if I could proceed, my lords, ground one, severance. We say that the learned trial judge erroneously failed to sever the cases of the two accused when it was patently clear, or we should say it became patently clear, that the intermingled and convoluted nature of the allegations and admissible and inadmissible evidence against the two accused would require and did require the jury to perform mental gymnastics and intellectual acrobatics of Olympic proportions, which resulted in the appellant Burgess being sorely prejudiced. And that's what I colloquially call the tangle.
When you say became rather than was, are you suggesting that during the course of the trial, the argument for severance became irresistible or became less resistible?
I would say that during the trial, my lord, the issue of whether, as things developed and it became clear how convoluted and intermingled the cases were and the difficulties that we would face, the issue of whether severance should have been granted was again raised, but was not formally applied. No formal application was made to the judge because of the matters that I've already put before you, that I realized and was pretty sure we would be met by a complaint that such had already taken place.
Well, when you say that as the things developed, severance was again raised, I don't quite know what you mean by that. Do you mean that you said to the judge, it's apparent in the way in which things have developed that there ought to have been severance, but there's nothing you can do about it because the Simmons J has already made a ruling?
Essentially, that is the position that was taken, yes, my lord.
But Mr. Richardson, what you're telling us is, as I understand it, that there's no justification for this practice of one judge regarding himself as bound by the finding of another judge in relation to the issue.
Well, my lord, I wasn't sure if it would be impolite for me to say that in that way. I did try to hint that I don't understand that particular practice, but that is the practice that I was faced with when I came to this bar. And that is the practice that I have adhered to.
I mean, there are problems with that. One Supreme Court or in England High Court judge is not bound by the findings of law of another High Court judge, though they are of persuasive. They are persuasive in content, depending on the rank and depending on the reputation of the judge in question. But this is a perfect example, one might think, of the reason why there shouldn't be any such rule, because what you're saying, what had to be determined was whether this trial, the previous one having been abandoned, whether this trial should proceed. And if the position was that as this trial proceeded, it became ever more apparent that severance was required, that would be thought to require a fresh determination on the facts as they had then developed, which ex hypothesi were not before the first trial judge, as to whether severance was needed.
Yes, I accept that, my lord. However, that is not the practice that we have been accustomed to here before these courts. And that's
okay.
How far did the first trial get?
I think we got maybe a day or so in. Miss Mulligan's recollection, I don't even think it was that long, but it didn't last very long before the judge was unable to continue.
Not much evidence.
No, sir, not much evidence at all. So in fact, I think it would be fair to say that the trial judge that did make the initial ruling on the severance application didn't even get far enough to see things develop the way the second trial judge did.
It must be the case that if in that scenario there is a change of circumstances, things appear which had not appeared at the time of the ruling in the first trial, that a change of circumstances must enable a further application.
Yes, my lord, I agree with you that under ideal circumstances, we would have liked to have felt unconstrained to make such an application and to take that particular route. But in light of the practice that we were faced with, we focused our resources on dealing with the trial that we were dealt. And as I said, it was always my understanding that if things did not go as hoped, that this is an issue that this court would have to revisit afresh and make its own determination. And so that is why we put it before you at this stage. But hopefully, the records that Mr. Coelho will hopefully locate will answer some of the questions that my lord actually has.
Well, I was just going to interject there and say that I've checked the dates that I've been provided, which was the 2nd of July to the 9th of July, 2019. And the only thing that the record shows of there any ruling having been handed down was an application which was made by you, Mr. Richardson, on the basis that the defendant should have been allowed to challenge more than the 3 jurors because they should have been entitled to challenge up to 5 since it was a pre-amendment.
That was one of the applications, yes. And her ladyship ruled with me on that, but ruled against me on the severance. There should definitely be a severance application in that package. We will try our best to pin down the dates for you.
Yeah, I'll continue to listen.
What you're going to be asking us to do is to say the judge in her ruling was wrong.
Yes, my lord.
That's rather difficult if we can't see what she said.
My lord, I appreciate that. Part of what I'm asking you to do is to say that the judge was wrong in her ruling. But I think that the primary task I'm asking this court to perform is to look at the state of this case and the evidence itself, and to ask itself in the result whether or not, in hindsight, severance should have been ordered. And I think that's the way the authorities suggest the question should be asked at this stage. Because in some of the authorities, as I've read them, the fact that a defendant had been convicted on a case in which the evidence was somewhat equivocal sometimes can lead the court to see that severance may have been the best option. Severance can't always be seen with foresight. And in some cases, I've seen that severance is something that is recommended as an afterthought because of the way things developed. So essentially,
you may even be saying that the judge was right at the time, but was proved wrong by subsequent events. Is that what you're saying?
That is also another alternative way to look at it, my lord, yes. But in any event, the way I see the law is that you 3 eminent wise gentlemen are the resort that we come to when we ask for this court to consider whether severance should or should not have been granted. In that regard, I would ask that you allow me to conditionally make these submissions, and upon receipt of the information from the hearing itself, we can round it off.
Can you
When you say on receipt of information from the hearing itself, which hearing are you talking about?
The severance application that Mr. Quayle
Right.
is trying to look at.
I'm still slightly lost as to what, if anything, you said to the second judge.
Very little was said to the second judge, my lord, because we were all aware of what the position would be. I think all that was acknowledged was that that is the classic position, and we've left it at that. I do appreciate my lords think I should have probably pushed harder and probably made a second application at trial. But when faced with a situation where you have to pick your battles, the battle that you believe has already been lost is not the place to put your resources, especially when I was aware that I would get an opportunity, if it went wrong, to talk to this court and ask this court to make an assessment.
In the original trial, when an application was made, was it supported by Rogers?
I believe it was it. I believe it may have been. I think at that time, Mr. Daniels may have been lead counsel.
Yes, if I may interject, I did want to tell Mr. Quayle, I found an email suggesting that the severance application may actually have been argued on June 24th, 2019, contrary to the dates I just provided him earlier. And I believe we just...
Before the start of the first trial.
Yes.
Yes.
And I believe that we did simply support the application. I don't think any further arguments were made, but we supported Mr. Richardson's position on severance.
24 June.
24th of June, 2019. My email from Mr. Daniel suggests that was the date when Mr. Richardson argued the severance.
Thank you.
Just to be clear, Mr. Richardson, now you're looking at this with hindsight. At what point in the second trial do you say that you ought to have made an application? When had things reached a stage where severance had been refused, now it should be granted?
I believe I came to that conclusion, my lord, at around the time that we had the abuse argument with respect to the missing voicemail. I think that's when it became clear to me that the issues with respect to Ms. Burgess were so uniquely placed that a single jury having to consider all of those issues and all of the convoluted directions his lordship would have to give. Because after the abuse hearing, and I'm jumping ahead of it, his lordship basically ruled against us and then prescribed, this is the reason why he ruled against us, that he could cure it with, I guess, what you would call the judicial version of a vaccine by giving a good direction later. However, we never received either dose of that vaccine, as I'll hope to show you in the summing up. That's a separate issue, but it was at that stage that it became clear that the issues were so convoluted, they'd become so complicated that to ask one jury to consider them in the separate cases against the two would require them to do things that, quite frankly, no human could possibly do. I mean, let's be quite candid. We as learned minds of the law have a difficulty sometimes separating out information that we should and shouldn't consider. In a case like this, it was nigh impossible for that jury to put out of their minds the confession that Mr. Rogers allegedly made. In paragraph 25, my lords, we say, the crux of the prosecution case against Mr. Cleveland Rogers concerned the evidence of his two former girlfriends, Katrina Card and Danielle Furley, who testified that Mr. Rogers had confessed to murdering the deceased. The confession evidence was such that Ms. Card testified that Cleveland Rogers had told her that he murdered the deceased in exchange for payment of $5,000 from the appellant Burgess. That particular piece of evidence, I say, my lord, provided the why for Rogers, but it couldn't provide the why for Ms. Burgess. The confession evidence of Ms. Card and Ms. Furley was wholly inadmissible against Ms. Burgess. Now, whilst it's accepted, my lords, that the learned trial judge instructed the jury that the confession evidence was inadmissible against Ms. Burgess, we respectfully submit that his directions could not and did not, in the circumstances of this case, cure the prejudice caused to Ms. Burgess by being tried together with Mr. Rogers. Section 515 of our criminal code rules that when two or more persons are charged in the same indictment, whether with the same or with different offenses, the Supreme Court may at any time during the trial, on the application of any accused person, direct that the trial of the accused persons or any of them shall be held separately from the trial of the other or others of them. And for that purpose may, if the jury has been sworn, discharge the jury from giving a verdict as to any of the accused persons. So that provision clearly allows a judge to consider the issue of severance, not just before the trial.
Well, just a minute. What about the words on the application of any of the accused person? Doesn't that suggest that there has to be an application made to him?
Well, my lord, that would run a coach and horses through the rule, the principle that a trial judge must keep the fairness of the proceedings under review. And if the trial judge of his own volition, and we say at this stage, at some stage, he should have at least cottoned on to it, thought that the issue should be reissued, that particular wording in that section would not prevent him from doing so. So my position would be that the issue of severance can be raised by the judge in his own wisdom. No one could stop him. Or you're right, it could be raised by counsel on behalf of one of the accused. I would hope that I've given an adequate explanation as to why I didn't raise that issue stridently in the second trial. And I would hope that that particular omission would not be held against Ms. Burgess, because it was based on my understanding of what I could and couldn't do at the time. So I do agree with you that those words are there, but they are not determinative. They are not a conditioned precedent to the issue being considered by a Supreme Court judge during the course of a trial.
It's very odd. You say that in the light of the practice at the time, you couldn't apply, but that the judge, in circumstances where you didn't apply, should have made a decision himself.
Well, my lord, I say that I was faced with a practice which said I couldn't apply. I firmly believe what your lordships have said, that I could and should be allowed to apply.
Yes.
That's the position.
I mean, if the practice was valid, the judge presumably couldn't do it of his own motion.
Well, I wouldn't think so, my lord. I think if he was being asked to revisit a previous ruling, perhaps he might take that position. But if he was being asked, or if one thought they could ask him to make a new fresh ruling based on things that have developed, then that would have been done. But it wasn't our understanding or my understanding at the time that that particular course would have been entertained at all.
Right.
In paragraph 30, my lord, I just need to bring up case law.
This practice that you refer to, is there a ruling sometime in the past that it is founded on, and did it consider section 515?
There are judicial rulings in which that particular principle is alluded to at the Supreme Court level. I cannot recall any of them at this stage. I can answer the second question, my lord. I am not aware of any that have dealt specifically with section 515, no. But I think if you will ask any member of our bar, they will confirm for you that that has been and long is the practice.
No, sorry to interrupt, but I think if one look at section 476D of the Criminal Code, which deals with case management rulings, subsection 2D and 476D4 as read with 476D subsection 5 may assist with this discussion.
What does it say?
476D, 2D says, 2 says a judge may also adjudicate, this is dealing with powers exercisable at a case management hearing. 476D subsection 2 says a judge may also adjudicate any issues that can be decided at a case management hearing, including those related to, and 2D specifically deals with the severance of counts. If one continue to read at 476D subsection 4, says subject to subsection 5, a ruling made under this section has binding effect from the time it is made until the case against the accused person, or if there is more than one, against each of them is disposed of and the case against an accused person is disposed of if, and it goes through if he is acquitted and so forth. Subsection 5, that's 476D, subsection 5 says, a judge may discharge or vary or further vary a ruling made under this section only if it appears to him that it is in the interest of justice to do so, and a judge may act under this subsection A, on an application by a party to the case, or B, of the judge's own motion. Subsection 6, no application may be made under subsection 5A unless there has been a material change of circumstances since the ruling was made, or if a previous application had been made since the application or last application was made.
Thank you.
May I continue, my lords?
Yes.
The next paragraph in my skeleton deals with the case of R versus Sims, and I don't intend to take you through that case copiously. It's simply cited for the principle that it enunciates, which is found on the first page of the judgment. It's found in the commentary section, and I need not go any further.
So do we have it in the authorities bundle?
It's in the digital bundle that Mr. Coelho very helpfully set up.
So what's the tab number?
There is no tab number in the digital bundle, my lord. There is
So if I've got a hard copy, it doesn't appear in the hard copy.
No, my lord, you shouldn't. My understanding is that we will be making references to the cases from the OneDrive box, which is very easy to use, actually. I'm really glad that Mr. Coelho set it up the way he did.
All right.
And on the first page of Sims, there reads a passage, or the citation I should put into the record is Criminal Appeal Report 158, 31 Criminal Appeal Report at page 158. The mere fact that evidence is admissible on one count in an indictment and inadmissible on another is not in itself a ground for ordering the counts to be tried separately. But where it would be difficult in the course of a summing up to distinguish the evidence relating to the respective counts, there is therefore a risk that the jury, when considering one count, may be unable to disregard the evidence relating to another count, and there's a ground for ordering separate trials. And that's the general principle. Throughout the course of the learned trial judge's summation in this case, my lords, the jury, there were repetitive overlaps, and I'll show them to you momentarily, between the cases and admissible evidence against both of the accused. The learned trial judge interchangeably went from directing the jury in respect of a piece of evidence admissible and relevant against Mr. Rogers to directing the jury in respect of evidence pertaining to Ms. Burgess. In the circumstances, it was nigh impossible for this jury, we say, to distinguish the two cases despite the learned trial judge's directions. The prosecution's case and the learned trial judge's summation, we say, focused on the issue of motive to such an extent that Ms. Burgess was unduly prejudiced, as the evidence of motive emanated from the inadmissible, insofar as it concerned Ms. Burgess, confession evidence of Ms. Card and Ms. Foley. Prosecution presented the background evidence, my lords, in such a way as to invite the jury that the defendant shared a common purpose or motive for committing the offense. In this regard, I'd like to draw the court's attention to the following extracts from the learned trial judge's summation. The first one is found on page 66. And it's line 12 to 23. At line 12, secondly, the prosecution contends that the evidence of their relationship, whilst it continued, the breakdown of that relationship and their breakup as a result of Marcus moving out of the apartment, provides a motive to Ms. Burgess for the premeditated murder of Marcus Gibbings. She is, they say, a woman scorned, They say that this background evidence establishes that she bore Marcus Gibbings ill will and had the motive to attack him or have him attacked. It goes to support the prosecution in their case that it was Miss Burgess rather than some stranger that had motive to harm Marcus Gibbings. If we then go to page 67, lines 15 to 24. Of course, in respect of the case against him, when you come to consider the case against him, it's suggested that he too had a motive. But in his case, as Ms. Card suggested in her evidence, Clevey, meaning Mr. Rogers, saw the dollar signs, a reference to the $5,000 that he's alleged to have told her he got paid to kill Marcus. But I'll remind you again that that evidence is only admissible against Mr. Rogers and is not admissible against Ms. Burgess. We then go to page 68, lines 15. Which lines 15 on page 68 begins, ultimately, ladies and gentlemen, it's a matter for you. But it's said by the prosecution that both Mr. Rogers, in respect of the money, and Miss Burgess, by reason of her ill will and hostility towards him, had motives for premeditated murder of Marcus Gibbings. So let me give you a directional motive also. First, the motive by which a person is induced to do an act or to form an intent is immaterial to the question of criminal responsibility. Motive is not an element of which the prosecution have to prove. The next reference, my lords, is that page, I think that might supposed to be 69.
It is 69.
Line 3 to 10. So we're going to hand out now for you copies of the indictment, also copies of another document respective from further particulars and in respect of the prosecution case against Ms. Burgess. And Mr. Mahoney, I got told off for doing your job for you. Excuse me, sir. I got told off for doing your job for you, which is that the indictment, I'm not aware of it. And it goes on, I believe, over to page 71 at line 10.
Mr. Richards, I'm sorry, I've said this before. When you, so far as I'm concerned, when you move to your
sorry.
right,
I move away too far. Yes,
go off microphone.
Yes. Sorry, my lord. Can you hear me now, clearly, my lord?
Yes.
Yes, perfectly.
Page 235 is the next reference.
Sorry, just on 69, did you take us over to page 70 or?
69.
Where do we start? Line 3 to 10?
And I think it goes over to page 10.
To page 70?
Yes. There are other references I will take you to also, my lord. The next reference in the list is page 235, lines 12 to 19. And at 235, line 12. Beg your indulgence, I'm not sure that that reference is correct.
Well, I suspect it is, because that's where he says robbery is not likely to be a motive because the very expensive watch was left on his wrist.
Yes,
And these are all references to what the judge was saying about motives.
about motive. Yes, my lord. Those are the references to motive. My lords, we've also included in our bundle a case that I'm sure you're all well familiar with. And it's there just for reference sake.
Does it have a name?
Yes, Norman, my lord. I'm sorry. R versus Norman, 1915, 1 Queens Bench Division at page 341. And we have actually extracted in the submissions that portion of Norman which we intend to rely on, so I don't need to take you, I would think, through the case. And that is found pretty much on the first or second page, where the court in Norman held. We desire to add this: in cases of this kind, where there are several counts and several transactions, in order that the counts charging the prisoner with obtaining chattels by false pretenses and the counts charging him with obtaining credit by false pretenses should be dealt with on a proper direction, we think the right course to follow is to try the prisoner upon one count or the other, and not upon all at the same time. If he is tried upon all of them at once, very serious difficulties may arise, inasmuch as evidence which is admissible on the charge of obtaining credit by false pretenses may not be admissible on the charge of obtaining chattels by false pretenses. And when all the evidence on both charges is before the jury, it is very difficult, if not impossible, for them to separate the evidence when they have come to consider their verdict. It is therefore highly important that the prosecution should be called upon to proceed on one count at a time, and that the prisoner should not be tried on all at the same time. Now, my lords, the reason why we say, before I go on, that it was difficult, if not impossible, for them to separate the evidence when they came to consider their verdict is this: the common crux of the case against both, albeit that on one defendant's case it was inadmissible and on the other it was admissible, was that the reason that Mr. Rogers, according to the Crown's case, was there to kill Mr. Gibbons is because he was paid to do so by Miss Burgess. That singular piece of evidence, I can't conceivably see how it could be used in the case against Mr. Rogers alone by any person who was considering the matter, because it also filled in the final blank in the case against Miss Burgess. And one can see how it'd be difficult, if not impossible, for that jury to separate the two. Because the Crown's case carried them this far to say that Miss Burgess supposedly lured Mr. Gibbons to 10 Derwent Lane. But the story can't be completed without reference to the inadmissible material as far as Miss Burgess is concerned. The second half of the narrative, the sting in the tail, as it were, is, well, she knew Mr. Rogers was going to be there to kill him because she paid him to do so. But all of that emerges from evidence which is totally inadmissible against her. And telling a jury to ignore one whilst relying on the other was totally useless. There's no way that jury would have been able, as we've said, to perform mental gymnastics of those proportions, not in a case of this nature, where the very linchpin which held both carriages together was a piece of evidence that was inadmissible against one, but admissible against the other. In paragraph 36, my lords, we refer to a case called Mogul. And the citation for Mogul is 1977-65 Criminal Appeal Reports at page 56. In that case, I have highlighted the portions that I will take you to. They are very brief. The first portion that I will take you to, my lords, is found on page 11 of the judgment. I should start on page 10 because that gives context. At page 10, there is a caption which says the decision to order separate trials. And beneath that, their lordships say, we are not as impressed as was the judge with the risk of prejudice to Sadiga had she been cross-examined in the course of a joint trial by her co-defendant on the psychiatrist's report. Further, we think that only in very exceptional cases is it wise to order separate trials when two or more are jointly charged with participation in one criminal offense. The present case is an object lesson of the risks. The risks were analyzed by Lord Goddard, Chief Justice, in Rondowski v. Malinowski, 1946. In the course of delivering the judgment of the court in that case, he said, page 371, prima facie it appears to the court that where the essence of the case is that the prisoners were engaged in a common enterprise, it is obviously right and proper they should be jointly indicted and jointly tried. And in some cases, it would be as much in the interest of the accused as of the prosecution that they should be. Suppose, for instance, that the defense was that he or she was acting under the positive duress of the other. It would be obviously right that they should be tried by the same jury, who might see in one prisoner a harmless or nervous looking little man or woman, and in the other a savage brute whom they might deem capable of forcing his co-prisoner against his will into assisting in a crime. The question is for the judge in the exercise of his discretion, and thus that the law has been stated ever since that the appellate court will intervene only if satisfied that the judge's decision has caused a miscarriage of justice. In other words, the ultimate question is that which, in any event, we have to consider. Was the verdict of guilty a safe and satisfactory one in all of the circumstances? And that is why I say that this question of severance, to a certain extent, does require your lordship to look at the matter with a bit of hindsight and to ask yourself that question. Was the verdict of guilty safe and satisfactory one in all of the circumstances, including the question of whether or not these cases should have been tried together? Because let's be honest about it. This is not a case in which there was some allegation that one defendant was exercising duress over another. There was no harm to the Crown in trying Mr. Rogers first on the evidence that was admissible against him, and then Ms. Burgess afterwards. There was no difficulty in that. In fact, what you'll notice is that the witnesses which would have given evidence against Mr. Rogers and the witnesses that would have given evidence against Ms. Burgess can be cleanly separated into two separate camps. And the only witness, if any, that you might have to call on both trials would probably be the forensic witnesses, which would likely have been agreed on the trial of Ms. Burgess the second time around, because we played no part really in examining them. That was not our issue. It was not alleged that our client was there or in any way visited the crime scene. So that's the position we take in relation to this. And at 37, my lord, we say that it is open to this honorable court to make a finding that the learned trial judge ought to have ordered severance if, in the words of Lord Widgery, in the case of Joseph, something has gone clearly wrong. And we've included Joseph in the bundle, and I won't take you through it, but that is a principle that is enunciated, and I don't think anyone takes issue with it, that this honorable court can indeed interfere if, in hindsight, it looks and it sees that, well, in the circumstances of this case, where severance wasn't ordered, something is clearly going wrong. Now, what I do have to say, and I sent an email, paragraph 38, is that at paragraph 38, we say that Lord Widgery, Chief Justice in Joseph, cited Smith. That was the wrong reference. In fact, the case is Lake, 1977, 64 criminal appeal reports at page 172. And I did upload it to the digital bundle once I realized the error.
What was the page reference, Mr. Richardson?
Page
64?
reference, Lake.
Yeah, I've got 77, 64 criminal appeal reports.
64, volume 64, criminal appeal reports at page 172.
172.
Yes, sir.
Thank you.
And I did again highlight passages here that I'll take you straight to so that I don't have to have you trolling through the entire case. And I could start at page 5 of the judgment. And there's a paragraph on page 5 which begins, before the trial judge, Mr. McCullough, appearing for the appellant, applied for a separate trial, and the basis of his application was that as things stood, the statement by Brookbanks and the statement by Dry would go before the jury, alleging that Lake had set up the burglary. It was submitted that whatever direction the judge gave to the jury about the inadmissibility of that evidence, in fact, was bound to be prejudicial to the appellant. The judge declined to order separate trials, and we think that he was right. It has been accepted for a very long time in English practice that there are powerful public reasons why joint offenses should be tried jointly. The importance is not merely one of saving time and money. It also affects the desirability of the same verdict and the same treatment shall be returned against all those concerned in the same offense. If joint offenses were widely to be tried as separate offenses, all sorts of inconsistencies might arise. Accordingly, it is accepted practice, from which we certainly should not depart in this court today, that a joint offense can properly be tried jointly, even though this will involve inadmissible evidence being given before the jury and the possible prejudice which may result from that. Of course, the practice requires that the trial judge in such a case should warn the jury that the evidence is not admissible. And this trial judge was certainly not lacking in his duty in that regard, because he, on no less than 11 occasions, pointed out to the jury that the evidence in question was not admissible. However, the exercise of severance is primarily one for the trial judge. The discretion was properly exercised in the present instance, and notwithstanding the fact that there must have been some risk of prejudice, the decision of the judge, we think, was right. Of course, if a case is strong enough, if the prejudice is dangerous enough, if the circumstances particular enough, all rules of this kind must go in the interests of justice. But this is not the sort of case in which the ordinary rule of practice, in our judgment, will operate unduly to the detriment of the accused, and therefore it is a case in which we should apply the ordinary rule. Moving on from there, at the close of the evidence for the prosecution, Mr. McCullough submitted that there was no case to answer. He was, in effect, as we see it, going over the same ground again. He was, of course, inviting the judge to consider the evidence which had been given, rather than the evidence which was in prospect of being given, as on the former application. There does not seem to have been any reason why the judge should have come to a different conclusion on the second submission than he did on the first, and he, in fact, refused the second submission. We think he was entitled to do so for the reasons already given. Then the matter went before the jury, and the jury returned the verdicts to which I referred. The matter now comes before us for the third and last time to consider whether the possibility of prejudice, which I have endeavored briefly to summarize, was sufficient to cause us to say that the conviction was unsafe or unsatisfactory. In this court, as everybody knows, the first matter we are concerned with is to see whether the rules have been obeyed and to see whether the trial judge has followed the rules of practice appropriate to the protection of the defense. Here he did, and in those circumstances, all that is left to consider whether nevertheless, notwithstanding that the rules were obeyed, the conviction is unsafe or unsatisfactory. The most helpful modern case on this topic is the case of Smith. The head note reads, the case for the prosecution was that the appellant and two other men who had made statements incriminating both themselves and the appellant had plotted together a large-scale theft. The three were tried jointly, an application by the appellant for a separate trial having been refused, and the judge gave a careful direction to the jury that the statements by the co-defendants could not be regarded as evidence against the appellant. I stopped there. That is almost a mirror image of the present case. The head note goes on. The jury acquitted the two defendants, but convicted the appellant. Held that if the case against the appellant had stood alone and no second or third man had been involved, and if the evidence had been confined to such evidence as was available against the appellant alone, it would have been insufficient to support a conviction, and accordingly it was unsafe and unsatisfactory within the meaning of Section 4.1 of the Criminal Appeal Act 1907, which was the appropriate act at that time. The facts of the case are interesting. The goods stolen were some platinum tips, goods of small volume. They were being sent by air from Heathrow to Liverpool, and the consignors, with past experience to guide them, would keep back the delivery of these consignments to the airplane so as to reduce the period in which pilfering could take place. The case for the prosecution was that the goods in question were being driven out to the airplane by one Mackenzie, that following upon a plan previously agreed upon, Mackenzie, whilst passing an office occupied by the accused Callahan, so purported to realize that he was short of documents, stopped his van and went into Callahan's office, according to his office, in order to get them. He left the van with the key in the ignition switch and the engine running. When the prosecution say that the van left like that was driven away by the appellant Smith, who had by arrangement with the other two placed himself at some convenient position for the purpose. The difference between this case and our present case is that Callahan and Mackenzie were both acquitted, although Smith, the driver of the van and the man who drove away, was convicted. It is really as though in the present instance, not only had Dry been acquitted, he having played a very small part in the affair, but as though Brookbanks had been acquitted as well. The real value of this case, we would respectfully say, lies in the principle which the court applied to this very similar situation. One finds this on page 27, where Edmund Davies, the Lord Chief Justice, as he then was, said, it was a case which, in the submission of Mr. Frisbee, counsel for the appellant, ought not to have been allowed to go to the jury. We are concerned more with the question whether the jury's verdict should be allowed to stand. The case presented to the jury and persisted in throughout, so that really no other case was left for their consideration, was that the appellant Callahan and McKenzie were right up to it in their criminal necks. The jury acquitted Callahan and McKenzie. They must have done so on the basis that they could not attach credence or sufficient degree of credence to the evidence which the police had given about their most damning admissions. At the outset, an application was made by Mr. Frisbee that the appellant should be tried separately from the other two on the grounds that despite the abundant, repeated, and very clear warnings of the recorder, that what McKenzie and Callahan said told only against them, and that despite their references to the appellant's complicity in their wrongdoing, those remarks would not operate in evidence against the appellant at all. Nevertheless, it would be bound to affect the minds of a jury. In our opinion, this is possibly a case where, despite those warnings and without in any way disagreeing with the exercise of the learned recorder's discretion to decide that the trial must proceed jointly, there is a possibility of that result having occurred. The case for the Crown was that these three men were in the plot together. The other two men were acquitted by the jury. Therefore, should the conviction of the appellant stand? My brother Brabin, in the course of counsel's submission, suggested, if I may say so, a useful test. Supposing there had been no second and third man in this case, supposing the appellant was the sole man indicted for this theft, and supposing the testimony against him was confined to that which we have been referring to in the transcript, would a jury be expected to convict upon it? And if they did convict, would this court regard the conviction as one which was safe and satisfactory to allow it to remain? We have come to the conclusion, and we desire to say no more, that in all the circumstances of the case, it is, in our opinion, unsafe and unsatisfactory. That is a very useful case we would gratefully accept as laying down the principles involved. But of course, although Brabin J had suggested a convenient test, these questions are not resolved by rules of thumb. Once you have decided that the rules of procedure were followed, and there remains the only residual question of whether there is a lurking doubt in the mind of the court, such doubts are resolved not, as I say, by rules of thumb and not by arithmetic, but they are largely by the experience of the judges concerned and the feel which the case has for them. For my part, I cannot see how anybody could have contended that Smith's conviction in the case which I have read could stand in the face of the acquittal of the other two. Where was all the planning? Where was the prosecution's story that this was a carefully planned raid? Again, if all the principals are not guilty at all. It seems to me that when one looks at Smith's case, the answer screams aloud that the conviction cannot stand. But it does not necessarily follow that the same applies in the case which we are considering. And their lordships go on to find that in that case, that the conviction was safe and satisfactory. But if I could return the court just briefly to the paragraph which precedes, we have come to the conclusion. The test that is set out, although it's not all encompassing, is helpful. And that is, supposing the appellant was the sole man indicted for this theft, and I'd say, suppose Miss Burgess was the sole person indicted for this murder, would the evidence admissible against her, when you remove what was admissible against Mr. Rogers, would that evidence not leave you with a lurking doubt? Would you be able to say, my lords, that you are confident that in the absence of the jury hearing about the confession evidence of Mr. Rogers, that they would inevitably have convicted Miss Burgess?
Well, it may go further than simply a lurking doubt. Let us assume, which is what you say that should have happened, and which is the test that Brabin J suggested in that case.
Yes.
Let us assume that the trial proceeded separately. And when you come to the trial against Miss Burgess, there would not be admissible, and the jury would not hear of the confession of Rogers to the two ladies.
Yes.
So the evidence that there was a murder in which she had given assistance would, I think, amount to the fact that Burgess was murdered by that Marcus was murdered by somebody. that the boots, the mark of the boots at the scene could have been Mr. Rogers, but could have been half the habitable globe as well.
Yes, sir.
That Miss Burgess had invited Marcus to go to the home stroke apartment.
Mhm.
And that's it, I think. isn't it?
Yes. Yes, my lord. And you've been very generous to the prosecution in that summary. But that
Why
is
have
my
I been-
point.
Why have I been generous in that summary?
Well, because you've given them the full benefit of the case taken at its highest, as you should.
Yeah, well, that's what I intended to do.
Yes, my lord. And
But
on
if the
that
case
analysis,
if the case at its highest could not support a conviction, the appeal is unsafe. The conviction is unsafe.
and that is our general contention, my lord, but it plays into the severance argument in the way as set out in Lake, because
Yeah.
this court now has to consider, well, looking at everything else, we now have to revisit the severance issue. And is it clear to us that if we take the evidence that is admissible against Ms. Burgess and put it to one side, and then we take the evidence that's admissible against Mr. Rogers and put that to one side, and if we maintain a parted river down the center and look at one and not the other, and in the absence of the other, it's our submission that the evidence which was admissible against Ms. Burgess was insufficient to safely convict, and a jury properly directed who followed those directions could not possibly have been sure or satisfied so that they felt sure. Not on the basis of the admissible evidence, and that's our position there. I think I have to take you to the case of Smith. I think there is a reference there that I need to bring to your lordship's attention. Smith. R versus Smith, George. The citation is 1967, volume 51. The criminal appeal reports at page 22. And the caption I wish to take you to, my lords, is found on page 6 of the judgment. And this is the case that his lordship was just talking about. And it begins, that was the case for the prosecution. It was a case in which the submission of Mr. Frisbee ought not to have been allowed to go to the jury.
Sorry, have we got that case?
Yes, my lord, you do. R versus Smith, George. It's in the digital Dropbox.
Well, I'm looking in it.
Ah, yes. Mr. Coelho has just helpfully shared it with the screen.
Right.
And yes, and he has the correct caption up. Well done. That was the case for the prosecution. It was the case which in the submission of Mr. Frisbee ought not to have been allowed to go to the jury. We are concerned more with the question whether the jury's verdict should be allowed to stand. The case presented to the jury and persisted in throughout, so that really no other case was left for their consideration, was that the appellant Callahan and McKenzie were right in it up to their criminal necks. The jury acquitted Callahan and McKenzie. They must have done so on the basis that they could not attach credence or sufficient degree of credence to the evidence which the police had given about their most damning admissions. At the outset, an application was made by Mr. Frisbee that the appellant should be tried separately from the other two on the grounds that, despite the abundant, repeated, and very clear warnings of the recorder, that what McKenzie and Callahan said told only against them, and that despite their references to the appellant's complicity in their wrongdoing, those remarks would not operate in evidence against the appellant at all. Nevertheless, it would be bound to affect the minds of the jury. In our opinion, this is possibly a case where, despite those warnings and without any way disagreeing with the exercise of learned recorder's discretion to decide that the trial must proceed jointly, there is a possibility of that result having occurred. And I would commend that to their lordships, that in this case, there is clearly a possibility of that very, very thing having occurred. The case for the Crown was that these three men were in the plot together. The other two men were acquitted by the jury. Therefore, should the conviction of the appellant stand? And the test by Brabin J is set out again.
It's not a severance case.
It began as a severance case, but
Yeah,
it,
but severance refused, and the court said there was nothing wrong with the decision not to sever. I mean, it became an unsafe verdict and an allowed appeal because of the rather unexpected events that the two people who'd made the confessions were acquitted and the one who hadn't was convicted,
yes, my lord.
which you could only tell after the event. That was the unfairness of it.
That was the unfairness of it. But the principle that is enunciated there, my lord, and the test that is set out with respect is it's two-stage. At first, you look to see whether or not the rules were followed. And then the next step is, in light of the fact that the accused were tried together and the result that actually came and the evidence upon which that result was based, are you, my lord, satisfied that this conviction is safe? It's our position that, as we've said already, when you parse out the evidence which was truly admissible against Ms. Burgess, let us not forget the three limbs: the motive evidence, which is immaterial and can carry you only so far; the background evidence, which didn't go to any of the elements of the offense whatsoever; and then the crucial elements, the third limb, as it's called, that she arranged to meet him at Derwent Lane. Even that evidence is inconclusive and open to competing inferences. And we all know the rule. When a jury is faced with competing inferences, in this jurisdiction, they are directed and were directed, and they should have followed that direction. If they had followed that direction, we wouldn't be here. That if there are two competing inferences, sorry, my lord.
If there had been severance and Mr. Rogers had been tried first and had been convicted, the prosecution could call him, whether he liked it or not, at the second trial.
For Mr. Rogers?
Yes.
I don't think they could compel Mr. Rogers, my lord.
Well, he's got no protection because he's already been convicted.
Yes, but I doubt that I'm not aware of any rule that would allow the Crown to compel a previously convicted co-defendant to give evidence against an existing defendant.
You don't think
I
there's
do
any
bow to my lordship's learning, but I'm not aware of any rule that would allow that.
you don't think there's any way in which in the subsequent trial of Miss Burgess, the prosecution could get before the jury that it was Rogers who was convicted of the murder?
I do believe they could put the fact of his conviction, but they
Right.
wouldn't need to call him as a witness.
That's as much as I wanted. That's fine.
Well, my lord, with the greatest of respect, what you said is if the prosecution called Mr.
Yeah, but I was assuming that you might. I wasn't anticipating that you would agree with what you've just said, so I'm content with that.
So they would be able to put the fact of his conviction before the jury. That is the principle. That is the way. Of course, I could argue against it, and I could ask that not be done. But it is possible that the fact. But however, that's the furthest that they would be able to go, to say that he was convicted. Not why, not that there was a confession in which Miss Burgess was said to have been the paymaster. So even that, the fact of the conviction is innocuous. It really doesn't take the Crown any further on the other elements that they would have to prove against Miss Burgess by virtue of admissible evidence. My lords, I'm reminded of the time, and I'm not sure if you want to take
I think now would probably be an appropriate moment since we're coming onto a new ground.
Okay.
My Lord President, just before the court adjourns, I just want to confirm that the ruling of Simmons J was issued on the 1st of July, 2019, following the arraignment session. It appears that she's reading from something, so I don't think that getting a copy of whatever she was reading from would be too tedious.
Thank you very much.
I'll try to get it to the court and counsel.
That would be very helpful.
Much appreciated.
Thank you. We will adjourn for an hour until 10 past 5 UK time.
Yes, my lords.
Thank you.
Uh, Justice Bell,
Yes, Mr.
could
Quayle.
you come over into the judge's room? I suspect Sir Christopher, oh, he's just going over.
I was actually trying to get back in because things froze on me.
Oh, right.
So
In the lower corner, you should be able to join the breakout room.
Well, we
We're just waiting
are
for
lacking
Justice Bell.
Justice Bell.
Give me a moment.
Okay.
Okay, I think the court is whole now.
Right.
Okay.
Yes. Yes, Mr. Richardson.
But corrections doesn't appear to be online.
Oh, thank you. Coelho?
Yeah.
We don't seem to have corrections online.
Ah. Well, they're here. Someone has to
Oh, are they?
engage the camera and the mic.
Hmm.
I'm not sure if there's someone on the other side. Let me see if I can get to the right phone. Okay, the intake office said they're going to call up top, see what they're doing. My Lord President, while we're waiting for the justices, is it possible for the judges to go to the breakout room very quickly?
Yeah, it is, yes, as long as we only take a short time there.
Yeah. Okay. Everybody
Um,
is here.
where is Miss Mulligan? Oh, there.
Mhm.
Where is Mr. Richardson?
Yes. Ah, good. Right, I think we're last all here. Yes, Mr. Richardson.
Good afternoon, my lords. Can everyone hear me again?
Yep.
Yes.
I left off in my submissions, my lord, I believe at paragraph 39,
Yes.
in which I made reference to the case of Lake and Smith first, and their lordship's distinction between prejudice, which often exists in and dangerous prejudice, and our position was that the prejudice here was dangerous. To move on to paragraph 40, to convict the appellant Burgess, the jury first had to be satisfied beyond reasonable doubt that Cleveland Rogers murdered the deceased. In this regard, we submit that separate trials would have caused little to no harm to Mr. Rogers or to the prosecution. However, the joint trial sorely prejudiced Ms. Burgess, and in these circumstances, following the dictum laid down in O'Boyle, the learned trial judge, we say, ought to have ordered separate trials. And O'Boyle, I have highlighted the passages. I will take you straight to them that we rely on. The first, let me read the citation, O'Boyle, 1991, volume 92 of the Criminal Appeal Reports, page 202. And when one gets to the judgment, on page 2, the held portion contains the statement of principle. And it reads, held that although it was necessary to retain intact, so far as possible, the discretion of a trial judge, the instant case was wholly exceptional, if not unique. The judge had given insufficient weight to the fact that separate trials would do little, if any, harm to a co-defendant or prosecution, whereas a joint trial would almost guarantee the appellant's conviction, whatever direction was given to the jury. Thus, the judge had wrongly exercised his discretion. And we do say that this is a case in which no matter what direction would have been given to the jury, it would almost guarantee, if they accepted that evidence, the confession evidence, the conviction of Ms. Burgess. The next passage, my lords, which I have highlighted, is to be found, it begins at the bottom of page 5 of the judgment with the words before arraignment. And it reads, before arraignment, counsel for the appellant applied for him to be tried separately from Rafferty. The basis of the application was that it was hoped to limit the evidence which Medin was likely to give to the effect that the appellant was linked in some way with the mafia, since the link was essentially hearsay. It was pointed out that since the appellant alone was charged in count 1, it meant that he would be prejudiced on that count by Rafferty's presence as a co-defendant on count 2. Rafferty's counsel at this stage supported the application. The judge refused to order separate trials on the basis that there were insufficient reasons for departing from the usual rule that conspirators should be tried together. The next reference begins on page 7 with the words, the main burden. The main burden of the appellant's argument is that decision of the learned judge, namely, that there should be no separate trial for the appellant, was wrong. Mr. Soley for the appellant concedes that in light of the authorities, and in particular, Grondowski and Malinowski and Miller, the general rule is that conspirators should be tried together in order, among other things, to avoid taking advantage of the other's absence to secure an unjust acquittal. Indeed, Lord Goddard, Chief Justice in the former case, said this at page 19, paragraph 19 and page 371 respectively. In some cases, it would be as much in the interest of the accused persons as of the prosecution that they should be tried together. Suppose, for instance, that the defense was was that he or she was acting under the positive duress of the other. Of course, that's not this case. If obviously would be right that they should be tried by the same jury who might see in one prisoner a harmless or nervous looking little man or woman, and in the other a savage brute whom they might deem capable of forcing his prisoner against his will into assisting crime. In Miller, Devlin J. had this to say, I think that in charges of this sort, justice ordinarily requires that the whole matter should be tried as one case. and that it needs a very strong and exceptional case before it's split up into two separate trials. If separate trials were to be ordered as a matter of course, simply because one prisoner proposed to attack the character of another, then a separate trial and the possible advantages in the case of the guilty prisoner could always be obtained simply by the threat that one prisoner proposed to attack the character of his fellow prisoner. It is submitted that this is a strong and exceptional case, and indeed Mr. Surley goes so far as to suggest that it is difficult to imagine a case where more harm could be done to a defendant and less to the prosecution and co-defendants than the present. The judge had already ruled manifestly correctly that to admit the DEA confession would have an adverse effect on the fairness of the proceedings. It was obtained in circumstances which cast grave doubt on its voluntary nature and reliability. It amounted to a confession of guilt on count one. Once before the jury, it would be a practical impossibility for them to ignore it. And we say that that was the situation also in this case. The appellant could be tried on count one, which was the gravamen of the case against him, on which he alone was charged without any danger of inconsistent verdicts or of one defendant taking advantage of the absence of another. So far as Raftree was concerned, the disadvantage of him not being able to attack the appellant by recourse to the procedure provided by Lord Denman's Act was in the circumstances minimal. We pause there at that stage, my lords. I pause to say that we wholeheartedly agree with the sentiments expressed there. This was a case, the case in which your lordships are considering now, the case of Ms. Burgess, in which there would have been no harm to Mr. Rogers in having a separate trial. There would have been no harm to the prosecution. There would have been virtually no overlap of evidence, and that which did overlap could have easily been dealt with by way of formal admissions, and there would have thereby been avoided any prejudice which we say could not be cured by a direction of a confession, if accepted as that, which in essence provided the missing link in the case against Ms. Burgess, i.e., well, how would she know that Mr. Rogers is going to be there and be in a position to kill him? How would she know to have sent him to Derwent Lane, etc.? That's why, and here's the why. Because according to Mr. Rogers in his so-called confession, and again, we say nothing about whether that actually took place or not, Ms. Mulligan will deal with that. The only evidence of that last missing link comes from Mr. Rogers' confession. There was no other way to complete the case against Ms. Burgess. So in essence, the Crown had to try them together in order to take advantage of that faux pas. We say this is a case in which the judge should have at least considered the fact that both of these cases could have been cleanly severed. In fact, it would have made more sense to try Mr. Rogers first, because let's say the Crown didn't get a conviction in Mr. Rogers' case. They probably wouldn't have proceeded to have a trial in Ms. Burgess' case. But if they did get a conviction in Mr. Rogers' case, as my lord has already pointed out, they could have prayed in aid the fact, just the fact, that he had been convicted and then had a trial with Ms. Burgess, which involved only the evidence and the witnesses that were admissible against her. That would have been the just thing to do, and it would have avoided the result that we did get, my lords. If I could continue, the next paragraph begins, we sympathize with the trial judge, faced as he was with the Privy Council decision on the one hand, and the heavy weight of authorities supporting the advisability of holding a joint trial on the other. We are also conscious of the necessity to maintain intact, so far as possible, the discretion of the judge in this and other cases. However, we have come to the conclusion that this was a wholly exceptional, if not unique case, and that the judge gave insufficient weight to the fact that separate trials would do little, if any, harm to co-defendant or prosecution, whilst a joint trial would almost guarantee that the appellant would be convicted, whatever direction was eventually given to the jury as to how they should approach the difficulty. It was, in our judgment, a wrong exercise of his discretion. Although no one could have foreseen what would happen, the judge's ruling did give rise indirectly to further difficulties. The appellant was in this situation. If he decided not to give evidence, there would be nothing to set against the evidence which Medin had already given. If the appellant decided to go into the witness box, he would be cross-examined on a confession which had been ruled inadmissible, and then further evidence would be given on it by the DEA officers, since the appellant did not admit the confession. The introduction of this evidence at that stage of the trial would understandably have a great effect. upon the jury. And my lords, what we say in this case is that there was an aspect of the confessions, I think it was evidence from Ms. Card, in which she said, and eventually I believe on cross-examination it was diluted, that she recalls an occasion when Mr. Rogers went outside and collected money from who she said was Miss Burgess. It turned out, so to speak, that she was unaware of who the person was that came. She never saw the person. And that the only reason she said that it was Miss Burgess who delivered the money was because that's what Mr. Rogers had said. It is conceivable that had she given evidence, my learned friend would have cross-examined her as to whether or not that incident took place, putting her in the unenviable position of having to answer to that when it is no part of the case against her, or should not have been any part of the case against her. But I cannot see a situation in which my learned friend would not have pursued that particular line of questioning. And if my learned friend says he would not have pursued it, then that makes the case stronger for us that there would have been no harm in the prosecution simply having or choosing to have separate trials. I don't think there are any more extracts in this case. Let me check, my lord. No, I'm done with this case of O'Boyle. And I'll move on in the submissions. Now, the next case I'd ask you to consider the case of Mia, 2011, M-I-A-H. It's found at 2011 England and Wales Court of Appeal, Crim 945. And again, I've highlighted the portions so I can take the lordships straight to the relevant portions. And the first relevant portion I would direct their lordships to, beg indulgence, is on page 14 of the judgment under the heading Grounds of Appeal Against Conviction, Akmol Mia. And it's paragraph 41, which begins, the principal ground of both appellants is that the judge refused to agree to there being separate trials of the two appellants. However, the basis on which the appellants put their arguments are not the same. We will have to consider them in more detail below. This was the sole ground for which the single judge gave leave to appeal, although within that one ground, he refused leave on one particular aspect. So far as Mia was concerned, I'm assuming that should read. This was that there should have been severance because of the sheer weight of expert medical evidence concerning Chowdhury that was before the jury, which led to unfairness against Mia. Mia proposed 4 additional grounds of appeal in his application to the single judge. The judge refused leave on each of them. Mia renews his application in respect of each of them. The first is that the judge erred in law when directing the jury as to how they should approach Chowdhury's evidence in relation to Mia. Whereas when rejecting the severance applications, 2 had been made in the course of the prosecution case, the judge had said that he would give a careful and firm direction on the admissibility of a co-defendant's evidence. It is said that he failed to do so. In particular, it is said that the judge failed to give a direction that what had been said by Chowdhury to his medical experts, and which was repeated in their narratives of his history of the offenses, was not evidence that could be used by the jury against Mia. We will call this Mia ground 2. I then move on. The next highlighted extract, my lords, is at paragraph 57, which is on page 19 of the judgment. And it begins, both Mr. Griffiths and Mr. Dennis accept that there are sound public policy reasons for having a single trial of defendants who are jointly charged with the same criminal offenses arising out of the same central facts. They both accept that it is therefore only in very exceptional cases that a judge should exercise his judgment in favor of ordering a separate trial for one or more defendants pursuant to section 5.3. Mr. Griffiths pointed to a case, R versus O'Boyle, where the Court of Appeal allowed an appeal on the ground that the judge had wrongly refused to sever a joint trial where subsequently one defendant had been able to adduce evidence by cross-examination of an otherwise inadmissible confession of a co-defendant. I then scroll down, my lords, to paragraph, I believe there's one more reference. In actual fact, those are the references in MIA, and they simply restate the principles that I've already put before you, my lords. In paragraph 42, we now ask you to turn to the summation that the judge did give. And I'd ask you to turn, my lords, to the judge's summations between paragraphs 49 and 65.
Oh, sorry, where do you want us to look at?
Begins at page 49 and goes through to page 65.
Sorry, I'm losing you again.
49 through to page 65. Sorry, my lord.
49 and 65, or 49 to 65?
49 through to 65. And the submission we make at this stage, before I take you through that, my lords, is that a careful analysis of this abstract, we say, demonstrates the rapid nature in which the learned trial judge mixed the summary of evidence interchangeably between defendants. The learned trial judge conflates the cases against the accused, despite his direction to the jury that the cases ought to be considered separately. If we begin at page 49, line 8, it's entirely a matter for you, ladies and gentlemen, whether you accept or reject these alleged motives to lie in respect of either Miss Card or Miss Furley. However, even you reject the alleged motives of Miss Card and Miss Furley to lie, put forward on behalf of Mr. Rogers, that does mean that either Miss Card or Miss Furley is necessarily telling you the truth. Remember, it is for the prosecution to satisfy you that Miss Card and or Miss Furley, because it would ultimately be open for you to accept part, all, or none of either Miss Card or Miss Furley's evidence, but it's for the prosecution to satisfy you that Miss Card and or Miss Furley is telling the truth, because it's the prosecution's burden to satisfy you, beyond reasonable doubt, of the guilt of the defendant. And given the totality of the evidence in the case against Mr. Rogers, I think you would really readily appreciate when you come to consider the case against him, ladies and gentlemen, that if you are not satisfied that the evidence of Miss Card or Miss Furley, or hence the confession alleged to have been made by Mr. Rogers, is reliable and true, then you could never, on the other evidence against him, be satisfied beyond a reasonable doubt, so that you feel sure of the guilt of Mr. Rogers. And so if you do not and are not satisfied that the evidence of Miss Card and Miss Furley is reliable and true, then you would have to return a verdict of not guilty in respect of Mr. Rogers. Now, part of the case for the prosecution against Miss Burgess is their contention that you can infer, if you find that Miss Burgess killed Marcus Gibbons' mother, Miss Sandra Herrera, that it could have been her, Miss Burgess, and not Marcus that was killed, because Marcus' death was a robbery that went bad, and 2 days before she had gone to the apartment on Dermot Lane to get her daughter's uniform, that Miss Burgess was lying about that, and that she was lying out of a consciousness of guilt in an attempt to deflect attention from herself. Of course, the defense for Miss Burgess is that the police told Miss Burgess that, and that she was simply relaying what she was told by the police to Marcus's mother. And when I come to consider the evidence in more detail, I will likely come back to that and the evidence of Chief Inspector Cardwell, to the effect that it appears that the Bulliver watch and the wallet of the deceased were still in his person and recovered from the mortuary during a post-mortem examination, which the prosecution are asking you to infer, but it's a matter for you, is not suggestive of any robbery of motive. Similarly, the prosecution contend that you can infer, if you find that Miss Burgess told Vernon Charles that two men came up from Trinidad to kill Marcus, that she was lying about that also, again out of a consciousness of guilt and an attempt to deflect attention from her. But the defense for Miss Burgess is that, again, this is something that she was told was being actively investigated by the Bermuda Police Service, and she was just passing on what she had been told by them. There may also be others, but given that the prosecution say that those were both deliberate lies that Miss Burgess told to cover up or deflect from your own involvement in the premeditated murder of Marcus Gibbons, I must give you a direction on how you should approach this evidence. In considering that evidence, you must consider three questions. Firstly, did Miss Burgess actually say any of what she was supposed to have said, either to Miss Ferreira or Vernon Charles? If you're not sure that she said any particular part of it, then you must completely ignore those aspects of the evidence on this point. if you are sure that Ms. Burgess did say some or all of what is contended by the prosecution, then ask yourself, what you find she said a lie? Or was she indeed simply passing on what she was told by the police? If you are not sure that any part of what she said was a lie, then again, you can safely ignore those aspects of the evidence on this point. If, however, you are sure that Ms. Burgess did say what is contended and that what you find she said were lies, you must ask yourself, why did she lie? You must be satisfied that the lie is concerned with some circumstances connected with the premeditated murder of Marcus Gibbons. You can only use the lie if that is what you find it to be against Ms. Burgess, if you are satisfied, having regard to all the circumstances, that it reveals a knowledge on her part of the premeditated murder of Marcus Gibbons or some aspect of it. You must also be satisfied the lie was told because Ms. Burgess knew that the truth of the matter would implicate her in the commission of the offense. In short, Ms. Burgess must be lying because she is conscious that the truth could convict her. There may, of course, if you find that what she said was a lie, be many reasons for that which do not arise from a consciousness of guilt on her part. After all, people do sometimes have innocent explanations for lying. So in answering these questions, bear in mind that a guilty
Mr. Richardson,
yes.
Mr. Richardson, what's this got to do with this ground of appeal?
Well, my lord, I think what you'll find is that.
I've lost you.
Sorry. I think what you'll find, and that's why we would ask you to do a careful analysis of it, is that in those pages, instead of dealing with the case of one defendant and that defendant's defense in a clean category, his lordship jumps interchangeably between the case against Ms. Burgess, the case against Mr. Rogers, the various defenses. And we
so far, he's only made the one jump from Rogers to Burgess.
Well, if you consider reading, and
right,
there are further jumps, and I would ask their lordships to save time, essentially, to note those pages, and in your deliberations, have a look at them. And you will, I hope, see what I say when I say that his lordship was duty bound in this type of case, we say, because of the difficulties and because there was no severance, to make
certainly at page 54, the judge goes back to the case against Rogers and the confessions.
Yes. And then I believe by
59,
page 59, he's back to the case against Ms. Burgess.
Yes.
And then by 61, he's back to the case against Mr. Rogers. But there's no clear delineation for the jury, remember, who is trying to sort this all out, trying to apply this complicated rule of law for the first time, keep this case separate. The judge was completely, and we don't say intentionally, unhelpful in conflating the cases in this way, especially where there was no severance. But what we do say on this ground is that when, as a judge finds himself in that position, where he cannot avoid going back and forth in this way between the evidence, that's a clear sign that perhaps the cases should not have been tried together, because the direction the judge is now being asked to give is most definitely a direction that a jury would have to perform Olympian mental gymnastics to be able to grasp and apply. Our position is that the judge should have given one cohesive block direction in relation to Mr. Rogers and given the instruction to consider his case first, which included the evidence admissible against him only and the defenses available to him, and then moved on after a clear delineation to the case against Ms. Burgess and the evidence that was admissible against her and the defenses that were available. So that's the point I make by making reference to those pages, my lord. There's a further reference, page 420 to 430, which I would ask you to treat in the same manner. And our submission with respect to those pages, 420 through to 430, those 10 pages, is that similarly, the learned trial judge's summation, he interchangeably directs the jury on the prosecution's case against Ms. Burgess, and then, before directing him on her defense, proceeds to outline Mr. Rogers' defense, which addressed matters which included, inevitably, Katrina Card's evidence, which was in fact inadmissible against Ms. Burgess. It was therefore impossible for the jury to distinguish the two cases and the admissible evidence in respect of each. I'd hate to put it this high, but for a jury who's coming to this with clean minds and trying to apply this very difficult concept, it may have looked like the dog's breakfast. And there's no way they could have disentangled, here's the tangle again, the confession evidence, which was admissible only against Mr. Rogers, from the rest of the evidence, which was admissible against her. And I want to make that point good because I believe, and by error, there's a case in the bundle which actually assists. I actually uploaded the wrong Trevon Soltis case. In actual fact, when we get to—
You're making a habit of this, Mr. Richards.
Sorry?
You seem to be making a habit of this, Mr. Richards.
Well, my lord, there's actually one was number 7 and the other was number 18. And I only recently discovered that I've actually uploaded, I think it was 7 when it should be 18. It was the same defendant had 2 cases. He had 2 appeals. That's what
Right.
caused me the difficulty.
Well, have we got the case you want on the cloud?
We have the extract of the important extract in the LaShaw and Simons case that my learned friend, Mr. Mahoney, provided. So I don't need the other Trevon Soltis case. But the one that is included will in fact be helpful, and I'll come to it. And it deals with this point of the importance of a judge tailoring his direction specifically to the circumstances of the case before him. To complete the severance ground, though, my lord, I'll move on. At paragraph 44, we submit that opposed to jointly referencing both accused, the learned trial judge had a duty to give specific and careful directions of the evidence as against each individual accused. The learned trial judge's directions, we say, require the jury to engage in mental gymnastics of an advanced and sophisticated kind. And this ultimately led the jury to being asked to engage in what can only be described as false sophistry in the circumstances of this case. And the failure to order separate trials has unjustly resulted in the unsafe conviction of Ms. Burgess. Now, before I leave this ground, my lords, I do just need to make quick mention of a matter because it will dovetail later into another ground, and at this point, it's just for note purposes only. But in the Crown's response at page 21.
So you've moved away from the mic.
Sorry. In the Crown's response at page 21, there's a paragraph 7, and there is noted an extract from R versus Hayter 2005 UK HL 6. And the Crown relies on that extract, obviously, to support their contention that severance shouldn't have been granted. And the extract reads, the practice favoring joint criminal trials is clear. It has been accepted for a long time in English practice that, subject to a judge's discretion to order separate trials in the interest of justice, there are powerful public reasons why joint offenses should be tried jointly, and cited there is the case of Lake. While considerations of the avoidance of delay, cost, and convenience can be cited in favor of joint trials, this is not the prime basis of the practice. Instead, it is founded principally on the perception that a just outcome is more likely to be established in a joint trial than separate trials. The topic is intimately connected with public confidence in jury trials. Subject to a judge's discretion to order otherwise, joint trials of those involved in a joint criminal case are in the public interest and are the norm. This practice hardly requires citation of authority, but in recent times, the practice has been affirmed by the Privy Council in Laubanne and by the House of Lords in Randall. Conceivably, in the present case, the middleman could have applied for an order severing his case on the ground that he might be prejudiced in a case in which a co-accused, Ryan, allegedly made a confession. The answer to such an application would usually be that the judge would give appropriate directions. That's one answer. The other answer, in some cases, such directions may include directions about the editing of a confession. And I simply put that there to indicate that at some point that will segue and does raise the issue that we would like to advance in ground 5. That is one of the cures, we say, to not granting severance. So that's how it arises. one of the cures to not grant, and Hayter was put before his lordship, to not granting severance, when one considers the case of dangerous prejudice of this nature, is to in fact redact, edit, or in some way limit the prejudicial evidence so as to cure it. But that wasn't done in this case.
Is there a ruling refusing to do that?
There is no ruling refusing to do that in this trial, no, my lord.
That's because the judge wasn't asked to do it.
No, my lord, the judge wasn't asked to do it in this case, but what I can say is that that extract that we just read was in fact put before him was put before the judge on the severance application. And that was part of the reason why it was dismissed. And I should hope that when we do get some transcript of that, of some recording, that will bear out. Hayter was hotly discussed, and that case was pretty central to our discussions on the severance issue. We beat Hayter like a dead horse, and I know that that particular remedy or potential remedy was before the judge.
So can you remember each time you say the judge, can you please identify which judge? I know you're talking about Simmons, Jay, but it makes a difference.
Before the first trial judge.
The first trial judge.
The first trial judge. The trial judge that made the ruling.
Yeah.
If I could move on now to ground two. Ground two deals with the application that was made for abuse of process. I think I should start by hearing their lordships, the judge's ruling on that, which I think can be found at pages 7 to 15. And my lords, on this point, we make two contentions. One is that the learned trial judge should have granted the application on the material before him. That's the first point. Two, having not granted the application and having cited as his reason for not granting the application certain curative measures that could be taken, the judge failed to take them by omission, inadvertently perhaps. But as I said earlier, and the metaphor I used was that the judge essentially found that there's a vaccine which can cure this and then failed to administer it. If I could begin at page 7. All right, I will deal first with the abuse of process application on behalf of Ms. Burgess, relating to the absence in evidence, if I can put it that way, of any message that may have been left during the 907-55 telephone call from Ms. Burgess's work number 2950925 from Marcus Giving's work cell phone 324-3441, and which it is not contested, went to voicemail and lasted some 33 seconds. Now, I paused there to note an utterance made by the prosecution in its response, in that they've never conceded that a voicemail was left. Well, that's pretty artificial, because unless, and we raised this during the trial, there was no dispute on the evidence that that call connected. There was no dispute on the evidence that that call went to voicemail. There was no dispute on the evidence that there was a voicemail left, which was recorded by the server's system as lasting 33 seconds. That's not sorry.
I thought it was the call that lasted 33 seconds.
Voicemail, there was a voice note that lasted 33 seconds. The call lasted 1 minute and 7 seconds, I believe. That's the 751 call, the one which I erroneously labeled as 715.
Right.
But the voice note, and I can show you the, I don't know if the lordships have it with me. Volume 2.
Sorry, what are we looking at?
It's volume 2 of the record of appeal, my lords.
Mm-hmm. Oh, yes.
And if you look at, and the debate stamp page is on mine, are little, I think it's page 336. or at the bottom, it's page 10 of 18. There are 2-page reference numbers, 336, and down the margin, page 10 of 18.
Yes.
My lords will look at the 3rd column down. You will see Katrina Burgess's work number, and this is a schedule prepared by the prosecution based on the raw data that was examined by the telephone expert. The date, 25/10/2006, the time, which when you adjust military time would be 9:07. The duration, 33 seconds. Then there's the destination. It went to Marcus Gibbings' cell phone. And then what happened to the call is also noted. Call forwarded to voicemail.
But as I read this, Mr. Richardson, that I inferred that the duration there is the duration of the call.
Oh, it is a 33-second call that was forwarded to voicemail. So whoever was speaking wasn't speaking to a person. They were speaking to a database that was recording what they were saying. So in essence, you are correct. It is a call, but it wasn't answered by a person. The record show was answered by Mr. Gibbons' voicemail, and that it then recorded 33 seconds of information.
Or silence, we just don't know.
Well, my lord, it would be amazing. And that's speculation, that someone sat there in silence for 33 seconds when before the court, from the police's own investigation, was Miss Burgess's account of what that voicemail contained. And 33 seconds sounds about right.
Yes.
So if I could, I just wanted to show you that in the record of appeal. If I could just go on. In cross-examination by Mr. Richardson, Chief Inspector Cardwell confirmed that in her statement to the police, dated the 26th of October, 2006, Ms. Burgess told the police what she says was contained in that voicemail. Now, keep in mind how soon that is after Mr. Gibbons' body has been discovered and his phone is taken into possession by the police. It's the very next day. And on the very next day, she is telling the police, I left this voicemail and this is what the content of it is. And it's clearly in response to the police questioning her, not yet as a suspect, but with some suspicion. And they put to her, you arranged to meet him down there, didn't you? No. I was going to meet him up the road and I left a voice note to that effect.
Mr. Richardson, do we have the material that is taken from her words to the police?
I think his lordship actually recounts it in his ruling, and I'm about to read it.
Right.
So Ms. Burgess told the police what she says was contained in that voice message she left for Mr. Gibbons. Namely, I was leaving the office. I hadn't heard from him.
Just forgive me a moment. I know that. What I'm wondering is, where is the material that contains
the statement?
Is it in the record?
Her actual statement. I'm not sure her actual statement was exhibited in the record of appeal. I don't think it was.
I don't think it was.
But no. Through cross-examination of the police, there was no dispute that that's what she, and his lordship goes on to actually say that subsequently, and I'll take you to it.
My lord, there was a transcript that I had requested of additional evidence delivered last week, and that includes the transcript of Mr. Cardwell, the officer.
Yes.
Which is a tab 5 of the...
In actual fact, the evidence that his lordship is about to briefly recount, he extracts it, I believe, from his note, which seems to have been of Mr. Cardwell's evidence. So if you want me to take you...
Mr. Richardson, you've moved away.
Sorry, if you want me to take you through Detective Cardwell's evidence verbatim, I can, but I can indicate that his lordship, having cross-referenced it, has aptly summarized what the gist of it was. I will take you to it if I have to, but I think once you look at it, you will see that that is the gist of what he did extract.
Well, why don't you just give us the reference and we can look it up if we need to, but we'll assume for the moment the judge got it right.
The reference, my lord, I think it would be during my cross-examination, which is at pages 133 to 183.
Yes. Well, perhaps at some stage you can give us a reference to the sentence, which isn't a reference to 50 pages.
Yes, my lord, I will do that. I can definitely do that.
Right.
If I could continue with his lordship's ruling on the matter.
Yes.
In cross-examination by Mr. Richardson, Chief Inspector Caldwell confirmed that in her statement to the police dated 26th of October 2006, Ms. Burgess told the police what she says was contained in that voicemail message she left for Mr. Gibbings, namely that I was leaving the office. I hadn't heard from him. I told him I was going to the lobster pot to get something to eat, and then to my dad's, and then he can reach me on my cell. Chief Inspector Caldwell also confirmed that it was not in dispute that Ms. Burgess did all of those things because the police confirmed that she in fact did. So the evidence of what Ms. Burgess told the police about that voicemail call is already in evidence in the prosecution's case by virtue of the cross-examination of Chief Inspector Caldwell. Mr. Richardson submits that the phone of Marcus Gibbings, Exhibit LI 32 and Exhibit 19 in the trial, was seized somewhere between the 26th and 28th of October 2006. And based upon the evidence of Kevin Cabral, that phone was in fully functioning state on November the 1st, 2006, when he examined it and made a note of the limited number of missed, dialed, and received calls, as well as the text messages stored on the phone. He could have, submits Mr. Richardson, but it appears from his notes that he did not, access the voicemail messages for that phone by simply calling the M3 Wireless voicemail number. However, the fact that the police considered this voicemail to be of importance to their investigation, notwithstanding that no one apparently thought to simply use the phone itself to seek to obtain it, is evidenced by the undisputed fact that the police, on both November 6th and 8th, swore warrants for the provision of the records of any such voicemail message left on the phone of Marcus Gibbons, which warrants were subsequently served on the service provider M3 Wireless. The court has also heard evidence from Ankesha Place. In evidence in chief, Ms. Place indicated that a request in the warrant for the production of voicemails would take 10 to 20 days from the date of receipt of the warrant by M3 Wireless. The voicemails at the time were stored, she said, in a server in the Cayman Islands and could be kept for up to 30 days. Ms. Place said that depending on the device, the limit on the amount of messages that will be held on the server was 7 to 10. The server, she said, which was used for all M3 Wireless subscribers at the time, once it reached capacity, would purge or automatically delete voicemail messages in order to create space for new subscriber voicemail messages. Further, once an individual device reached its capacity of 7 to 10 voicemails, no more voicemails could be left on that device. The voicemail box would return a message that the voicemail box was full, and so no voicemail message would be left. In cross-examination by Mr. Richardson, Ms. Place indicated that, depending on the information sought on a warrant, it could take between 7 and 21 days for M3 to provide the police with the information sought. She then confirmed, however, that she was able to provide the information requested in 2 warrants received by her section of M3 Wireless in 4 days in respect of one and 5 days in respect of the other, adding that responses can be provided faster depending on the circumstances and the nature of the information requested. Ms. Place confirmed that if someone bought in the phone, they would have been able to use that device to access the voicemails received by the phone. She was unaware of anyone having done that in this case. Ms. Place was unsure if, back in 2006, it would, as suggested, have been as simple as sending an email to the Cayman Islands to retrieve the email, the voicemails received on Marcus Gibbons' phone. She said she knew that at the time, they would fly people down to Cayman to do maintenance work and retrieve information from the server. But she really could not say how the switching engineers would go about complying with a warrant for the production of voicemails. She did agree, however, that an email or telephone call could have been made to Cayman to preserve specific voicemails on the server. Ms. Place also confirmed that if a voicemail was left on October 25th and a phone was provided to them or a request was made on November 1st for the production of that voicemail, it would still have been on the server, as that was well within the time limit. She was unaware if the police or anyone else in this case made such a request. In re-examination, Ms. Mahoney, Ms. Place indicated that she had never had a phone brought into M3 Wireless by the police service before. She also confirmed that while she was able to turn around the requested information of her in 4 to 5 years, she understood the process in respect of voicemails took longer as they were not stored in Bermuda. She added that if a voicemail left on the 25th of October was requested in a warrant dated November 6, it was not likely that voicemail would be retrieved because too much time may have already elapsed. Chief Inspector Cardwell, in his evidence, also confirmed that he would have expected his officers to, but could not say whether anyone, in fact, once the warrants were served, followed up to either confirm that the information was received or seek to ensure that it was. And there was no apparent record of what, if anything, was received by the police as a result of the warrants of November 6th and 8th seeking voicemails. The upshot of the evidence, therefore, is that whilst the police had the apparent desire and moreover the ability within their own hands to access any voicemail left during the 33-second call, they have, through what Mr. Richardson submits, is somewhere between gross negligence and deliberate omission, although there was no suggestion of the latter put to the police witnesses, or if it was, no evidence to that effect, failed to obtain and retain the best evidence of what was contained in any message left during the call. Where that leaves us, however, is in a position where the defendant has made clear repeatedly to the police, which is now in evidence before the jury, what she says the content of the message was. And whilst the prosecution may not be in the position to agree that that is what was said, they are certainly, by reason of the failure to obtain or retain it, not in a position to contradict Ms. Burgess. Against that evidential background, Mr. Richardson referred to the court to Ibrahim, which at paragraphs 8 to 16 sets out the UK 1997 guidelines and the new AG's guidelines, of which both derive from common law principles of the police duty to obtain and preserve relevant material, together with, at paragraph 70 to 28, a discussion of the jurisdiction to stay criminal proceedings for an abusive process, and at paragraph 29, a number of cases in which the principles have been applied. Additionally, Mr. Richardson referred the court to further authorities, Boyd and Clay, in which the same principles had been applied, all of which, perhaps unsurprisingly, to a greater or lesser degree, turn on their own facts. Mr. Richardson submitted that in the circumstances of this case, based upon the authority of Ibrahim, as well as Boyd and Clay, the court ought to permanently stay the case against Ms. Burgess, or to use the processes of the court, namely, in Mr. Richardson's submission, her no case act application to stop the case against her. Now, what needs to be appreciated at this stage, my lords, is that the application that was pitched to his lordship was that firstly, I argued the abuse point, and then I argued to him that if he wasn't with me on the abuse point, the fact that she had been denied without contradiction, apparently the Quran couldn't contradict, the best evidence of what she actually said in that voicemail. And let's be clear about this, my lords. Let's be crystal clear about this. The Crown's case at its highest is that she made a phone call at 7:51 in which she apparently, based on very ambiguous evidence, which is evidence of Mr. Gibbons' state of mind alone, made arrangements to meet him. Where, we don't know. I accept my lordship's point, he did go to Durban. But that was the state of the evidence against her. The difficulty that we have here is that when considering the no case submission, his lordship did not factor in, and I'll show you that in a minute, the fact that he had made that particular note, that part of the trial process could be that to deal with the abuse complaint, he could factor that into the no case submission, but he doesn't, and I'll show you that later, my lords. The next page, in response, Mr. Mahoney submitted that there was no substance to the claim and that in his submission, Ms. Burgess could receive a fair trial, the absence of any voicemail messages notwithstanding. He referred to the court, not for the first time in his trial, to the case of PR versus the Crown, a case in which the Court of Appeal considered whether the trial judge was right to allow the case to proceed when evidence gathered by the police in 2002, relevant to the appellant's defense, was destroyed by water damage and was unavailable for the trial in 2018. The appellant's submission was that the judge wrongly refused the application, which was renewed following the prosecution's evidence to stay the proceedings as an abusive process. At pages paragraph 65 to 71 of PR, the court refers to the prior authorities, starting with Ibrahim and finishing with Ali. I don't intend to take you through those paragraphs from PR. Applying the principles set out in PR, however, including Ibrahim, to the instant case, I return to the proposition above as to where we find ourselves. And that is in a position where the defendant has made clear to the police, which is now in evidence before the jury, what she says was the content of the message. And whilst the prosecution may not be in a position to agree that that is what was said, or even that a message was left at all, they are certainly, by reason of the failure to obtain and or retain it, not in a position to contradict Ms. Burgess. In these circumstances, I am unable to say that on the balance of probabilities, I am satisfied that the trial process, including any directions that I may give, is unable adequately to deal with any prejudice caused to the defense by the absence of this voicemail. I therefore dismiss the application for abuse of process on behalf of Ms. Burgess. So essentially, his lordship found that he could give directions, I suppose, which were to amount to the fact that the jury should take it as an uncontradicted fact, because they can't contradict it, that a 33-second voicemail was left, and that if they find that what was said in that voicemail in fact marries up with what she said in her statement, that would in fact amount to a coach and horses being driven through the Crown's assertion that she lured him to Derwent Lane, because the content of that voicemail clearly indicates that she had no intention to beat him at Derwent Lane. She had intention to meet him, but not at Derwent Lane. That rips a hole in the bottom of the Crown's bill. So I think at this stage, my lords, I should take you to the only reference I can find as to how his lordship actually did deal with that when summing up to the jury. Take your indulgence. Made a note of it. Beg your indulgence, my lord. I had it more. Okay, I think it's at 293, maybe at 293. Yes. If I could take you to page 290. 293 is where it begins, my lord. And at page 293, beginning at paragraph, line 4, in cross-examination by Mr. Richardson on behalf of Ms. Burgess, Chief Inspector Cardwell confirmed that if warrants were served on phone companies for telephone records and they only complied with 8 out of 10 requests contained in that warrant, they would have to provide an explanation for not providing the other 2, and he would expect officers to follow up on any failure to provide information pursuant to a warrant. He said that on the phone evidence, he said that the phone evidence was all forwarded to Lauren Bell for analysis, and he would have expected her to flag any missing information also. Apparently she didn't. He confirmed that there were several warrants issued for telephone information in respect of this investigation. He also confirmed that in her witness statement of the 26th of October 2006, Ms. Burgess indicated that she left a voicemail message on the night of 25th of October 2006 at around 9:10 p.m. on Marcus Gibbons' phone, in which she said she had told him she was leaving the office. She hadn't heard from him. She told Marcus, she said, that she was going to Lobster Pot to get something to eat and then going to her dad's house, and that Marcus could reach her on her cell. Now, keep in mind, my lords, also, that on the evidence and on the Crown's case, their position is that when she's made this phone call and left a 33-second voicemail, put aside the content for a moment, that Mr. Gibbons is already deceased.
Sorry, Mr.
There
Gibbons.
was no specific.
Sorry, say that
Already
again more
deceased. That's
slowly.
why he didn't answer.
Right.
Mr. Gibbons was already deceased. That's
Right.
why he didn't answer.
Presumably the prosecution case about this phone call was that it may well have said what she said it said, but it was, by reason of its timing, the final touch to her, as the prosecution put it, concocted alibi, having orchestrated these various happenings and sayings. The last thing she did was to ring a phone, which on the prosecution case she knew wouldn't be answered because Marcus was dead, and leave a message consistent with the alibi which they say she'd falsely concocted. That was the prosecution case, I assume.
My lord, yes, and that sounds like something out of a John Grisham novel, if I might say so, because where is the evidence at all that anyone was in a position to communicate to Miss Burgess that Mr. Gibbons was dead? She was at her office, we know this. There's no evidence that any phone call came into that office from anyone. There's no evidence she called anyone. There's no evidence she would have known that in making that phone call, she was making it and it wouldn't be answered. And she would have to be a Mensa Society genius to have configured in her mind that by leaving that voicemail, it would be checked and that they would then turn around and try to twist that in the way that they have. It just beggars belief that in that short time, anyone could credibly assert that that's what she was doing. This is a very, on the evidence, simple, I don't mean that as a derogatory, woman. And that particular type of narrative is something out of a Jeffrey Archer novel that might be entertaining, but it's not supported by any evidence, my lord, whatsoever. So, my lord, if I could continue. Chief Inspector Cardwell said that was not in dispute, that it was not in dispute that she left a voicemail, but he found it relevant only in so much as Marcus Gibbons did not answer the phone. That's the senior investigating officer assigning that relevance to a voicemail, and it beggars belief. You have a woman who you consider to be a person of interest, later elevated to a suspect there, and you're asking her about her movements, what's she done? How is it you appear to have arranged to meet this guy down? And her response is, oh, no. I left a voicemail when I didn't see him. I was never going to Durban Lane to meet him. And that voicemail says this. And it marries up with me describing exactly what I did do that night, as the Chief Inspector Cardwell confirmed. So let's not kid ourselves here. This evidence of this voice note, had she had it in her possession, conceivably, I can't see how the Crown would have mounted a case which relies on admissible evidence on one man limb, that she supposedly intended to meet him at Durban Lane and never showed up. This voicemail completely obliterates that suggestion, but she didn't have it, did she? Through no fault of her own, because she brought it to the police's attention immediately on being first taxed. It's almost as if the police had said, we're going to check and see if your DNA is in a certain place, to use my lord's DNA example. And the suspect says, well, go right ahead and check. I can tell you my DNA won't be found there. And then the police negligently failed to take the simple swab and send it away. After being challenged to that effect, I can bet you that there's no, not me. That's what happened in this case. He also confirmed that warrants were obtained and served to seek to recover that voicemail from Emprey Wireless, but was unable to say what, if any, information was received by the Bermuda Police Service in response to those warrants related to the voicemail. He said, in his experience, the police don't get voicemails from the telephone companies, and he added that if they don't get them, there's nothing he can do. But again, he did not recall if, in this case, they received anything in response to those warrants. He repeated again that it was not relevant to him in any event. He said Ms. Burgess told him what she said in the voicemail she left for the deceased, but Marcus didn't receive the call. So it sounded to him like Marcus was already deceased. That's his opinion. Of course, he can't say when it was that Marcus was deceased. He also knew that she did go to Lobster Pot after leaving her office because they spoke to the Lobster Pot people. He said he verified everything Ms. Burgess says she said in that voicemail. You may think, ladies and gentlemen, that what the chief inspector was saying there is that even if you accept, as he seemed to, that Miss Burgess left that message, that she said she did, and that she then did indeed go to the lobster pot, that is not relevant in Chief Inspector Cardwell's mind, at least, to the question of whether she had previously arranged to meet Marcus Gibbings at Derwent Lane. I'm flabbergasted that his lordship actually gave any credence to that in that passage to what was passing through Chief Inspector Cardwell's mind. His opinion was totally irrelevant. Of course, the defense for Miss Burgess says that her message, I'm leaving the office, I haven't heard from you, I'm going to Lobster Pot to get something to eat, and then going to my dad's house, you can reach me on my cell. If you accept that it was left, so in essence, the judge is still leaving the issue to the jury to decide whether the voicemail was left after it's conceded a voicemail, which the police had a duty to retain and abysmally failed to exercise, is no longer available to her. If you accept that it was left, it's clear evidence that the meeting was supposed to be at her office. It is clear evidence that the meeting was supposed to be at her office. Whether that is an inference that you draw from it or not, of course, is ultimately, ladies and gentlemen, once again, a matter for you. That's the only direction his lordship gives about how the jury could in any way assess, apply, and deal with Miss Burgess's inability to produce that voicemail. The authorities that we've relied on, in fact, the cure his lordship himself envisaged, must be greater than that. His lordship should have went far enough to say, listen, the police aren't in the position to contradict that Miss Burgess, and it's their fault that she doesn't have that voice note. So in essence, you should take it as a given fact, that if she says that happened and they're unable to contradict it, that's the evidence. His lordship did not make that clear. He basically said, well, it's up to you if you think it's relevant or not. But Chief Inspector Cardwell didn't think it was relevant, so hey, that might be relevant to you. And he didn't go anywhere near the type of direction that would have given a jury the proper guidance on how to apply the cure he says that saved him from having to make an abuse ruling. And that's the gravamen of it. So one, we say he should have acceded to the application. Because if that's the cure he had in mind, it was wholly insufficient. It didn't go anywhere near what she needed or deserved in this case. And it did deprive her of the right to a fair trial in a case where the central allegation against her was, you arranged to meet the man at Derwent Lane. And her response to that almost immediately is, no, I didn't. And I left a voice note, which you can check, to see that that is not what the plan was. I can't think of any more completely diametrically opposed situation than that. And furthermore, my lords, in every case in which such a cure is usually applied, the defendant has at their disposal other evidence with which to confront the gap. The only evidence Ms. Burgess had available to her was, oh, she didn't, did she? The voice note. She didn't have anything else to confirm her account. Chief Inspector Cardwell's word that I can't dispute it with her is not confirmation of her account. She had no other evidence with which to address this particular issue, except the evidence that the police, on an undisputed finding, failed to exercise a duty to collect and retain. I think in the submissions, my lord, and I'll try to move through this ground a bit more quickly. Without prejudice, at paragraph 55, to the position that the evidence against the accused was insufficient to support the charge of premeditated murder, had the police obtained and retained the voicemail that was left by the appellant on the deceased phone, the jury would have had the opportunity to assess the voicemail message, the tone and candor of the appellant's voice, and it would have been open to the jury to, having listened to the voicemail, summarily reject the Crown's assertion that moments before or prior to that voice message, the same woman leaving the innocuous and pleasant voicemail, hey, I haven't heard from you, contact me, I'm up my door, you can hit me up and go into my daddy's house, that that woman was plotting to have him brutally murdered. That's very important evidence that she's been denied through no fault of her own. And what we say we will make out was serious fault on behalf of the police. At the very least, my lords, had the voicemail recording been provided to the jury, they would have undoubtedly been entitled. In fact, if the voicemail said what she says it said, I'd say they would have been almost duty bound to reject or apply significantly less weight to the other admissible evidence adduced in respect of Ms. Burgess. The prejudice caused to Ms. Burgess by not having the benefit of the voicemail recording could not, and indeed, as I've shown, was not cured by the learned trial judge's direction. It simply wasn't. Instead of expeditiously pursuing this crucially important line of inquiry, my lords, the police, armed with the knowledge that if the appellant's account of having called the deceased and left a voicemail turned out to be true, were grossly negligent in delaying the swearing of a warrant to request the provision of records for any voicemail messages left on the deceased phone. Let's remember the timelines here, my lord, and I'll sketch it out. The 26th, Ms. Burgess is questioned. She then, on the 26th, tells the police, this is the voicemail I left. This is what it says. The police do not, until the 1st of November, actually begin to take any action whatsoever. That's almost, you know the timeline. That's over a week. Nothing's done. And then when something is done, it's Mr. Cabral looking at the phone, which he has in his hand, which he can access, but he doesn't. But then amazingly, this phone, which has this voicemail on it, which is so important, which the police almost seem to be deliberately driving around. They don't even want to go anywhere near it. They don't make a request until the 6th. That warrant's complied within 4 days. They make another request for the same stuff, 8th. That warrant's complied within 4 days. None of the voicemail messages are included, and not one of these professional policemen said, hey, remember that very important, what? That's not here. Shouldn't we follow up on that? That didn't happen, my lords. And it beggars belief that it didn't happen in a case of this nature. Paragraph 60, my lords, Ms. Ankesha Place, a prosecution witness, who was employed at the time by the telephone service provider M3 Wireless, confirmed by the cross-examination that if the police had simply bought the phone, M3 Wireless on November 1st, M3 Wireless could have assisted the police with accessing the voicemails right there. And her evidence was by that time, they would have still been there. Ms. Place confirmed that to her recollection, nobody for or on behalf of the Bermuda Police Service bought the phone to M3 Wireless to allow them to manually extract the voicemails. Now, stop right there, my lord, first and foremost. I am having a real difficulty that senior investigating officers such as Inspector Cardwell, Sabian, and the officers who were assigned to this case, experienced investigators, if you look back at their records, between them, they've got over 60 years experience, did not in any way appreciate and run down with alacrity an attempt to retrieve the voicemail from the phone that they know they had in their possession and that they know was in working order. They have on staff a gentleman who they eventually send the phone to a year ago, Mr. Cannoneer. Mr. Cannoneer was clear, they had bought me the phone, I got it. He didn't get the phone until a year after it was seized, and it was no longer even able to power up, according to him. I just can't emphasize enough that if this was not a deliberate omission, it's only because I can't point to red-handed evidence that it was. But everything else about it screams out the inference that the police didn't want that voice note. And they avoided it, I would say like the plague, they avoided it like a quarantine facility full of people with COVID. That would be a more relevant analogy. They stayed away from it, made every excuse. Paragraph 62, that the Bermuda Police Service failed to take the telephone to M3 Wireless for manual extraction of the voicemails was not contested by the Crown during the trial. No explanation was given for not doing that. Ms. Place also confirmed that notwithstanding that it could take any time between 7 and 21 days for M3 Wireless to provide the police with the information requested in a warrant, it could, depending on the circumstances, sometimes be done faster if M3 Wireless were given notice of the circumstances. What she was saying there, my lord, and you'll see it, Mr. Mahoney is helpfully provided, is that if we were told it was in relation to a murder investigation, well, we'd expedite things now, wouldn't we? And in fact, they did, because warrants, she says, they usually take between 7 to 21 days. M3 was turning them around in 4 days once the request was made. But the first official request for these records wasn't made until 2 weeks after my client had told them I left the voicemail. Astonishing. Ms. Place also confirmed, Ms. Place's evidence was such that she did not recall the police ever making any such note of urgency or special request in respect of the warrants, notwithstanding the importance of the evidence to their investigation. Ms. Place agreed that if the police had made a request on the 1st of November 2006 for M3 Wireless to preserve specific voicemails on their server, the 33-second voicemail on the deceased phone would have still been on M3 Wireless's server. Ms. Place confirmed that since the police delayed their pursuit of this line of inquiry some 7 business days between the appellant Burgess's 26th of October 2006 statement and the servant of the warrant request, the voicemail was not likely to be recoverable because too much time had elapsed by then. Chief Inspector Cardwell conceded under cross-examination that although he would expect his officers to have followed up with M3 Wireless after the swearing of the warrants, he could not be sure that any of his officers had followed up with M3 Wireless, not even to confirm that they had ever received the warrant. So this is a police force who served warrants. They're not checking to see if they've got all the information. They aren't even checking M3, say, hey, how come we haven't gotten that information? Did you get the warrant? These are normal follow-up, due diligence that you would expect from a police force that's actually trying to seek out the truth. Rather than, I'll say no more. Chief Inspector Cardwell confirmed that he did not view the voicemail evidence as being relevant because the earlier call was the focus of the police investigation. I stopped there. So the police essentially cherry-picked and said, well, phone call made at 7:51. That's important. She appears to be arranging to meet him somewhere. Oh, the voice message where she basically clarifies and it becomes clear that she wasn't meeting him where we say, but that's not important. That can't be right. That cannot be correct on any analysis of how a police force is supposed to operate. It cannot be, and it must trouble your lordships that no real effort was made to preserve this. On this basis, it was clear that the police did not pursue the retention of the voicemail message because they did not deem it to be relevant. The case law discussed below demonstrates that it is insufficient for the police to simply state that they did not deem the evidence relevant where the court finds that the police had a duty to retain the evidence. So in this case, I don't think there's much dispute. The court did find that the police had a duty to retain the evidence, but it also made note of the fact, amazingly, that the chief investigating officer simply didn't deem it to be relevant. And that was put before the jury in any event as a reason that they could take into account when assessing what to do with the fact that the voice note was missing. It's astonishing that it went that way, but that's the way it went, my lords. Paragraphs 68, in sum, the evidence in respect of the 33-second voicemail demonstrates the investigators' gross failure to diligently and expeditiously preserve all relevant material in connection with their investigation. Indeed, Chief Inspector Cardwell bizarrely confirmed that he could not confirm if the police ever received any information whatsoever from M3 Wireless in respect of the warrant served. The appellant's trial counsel launched an application to stay the proceedings as an abusive process on the grounds that the police had failed to retain and preserve the voicemail evidence. This application was rejected by the learned trial judge on the basis that he was satisfied on the balance of probabilities the trial process, including the directions which he was to give to the jury, would be able to adequately deal with any prejudice caused to the appellant by the absence of the voicemail. This ruling, we humbly submit, was a very unfortunate error in law. it is trite law that the learned trial judge had the inherent jurisdiction to stay the proceedings on the grounds of abuse of process. When considering an abuse of process application, the ultimate objective of the discretionary stay power is to ensure that there should be a fair trial according to law, which we acknowledge involves a balance of fairness for both the defendant and the prosecution. As a starting point, the learned judge ought to have noted that the police had been put on notice by the appellant of the presence of the potentially exculpatory evidence which went to the heart of their investigation, and yet still the police waited 2 weeks to belatedly swear and serve warrants requesting the telephone data. And then, having failed to make any note of urgency to the service provider in providing the circumstances, they ostensibly never followed up on the warrants, such that Inspector Cardwell could not recall whether any information was ever received in respect of the warrants. Putting the fact that the police belatedly served the warrants to one side, my lords, the learned trial judge ought to have considered that 1 week prior to swearing the warrants, the police on the 1st of November 2006 actually examined the phone, which was still in a functional state, to the extent that Mr. Cabral went through the phone to make a log of the text messages and calls on the phone. But astonishingly, this police officer neglected simply to call the voicemail to retrieve the crucially important contents of the 33-second voicemail message that the police at that time knew the appellant had left on the deceased phone. The learned trial judge ought to have taken judicial notice of the fact that the investigating officers leading this case were highly experienced and highly ranked police officers who undoubtedly were familiar with obtaining telephone data service from providers in the course of their duties, and thus would have been, or at the very least should have been, well aware of the expeditious nature in which investigative actions have to be taken to preserve telephone data before it is irrecoverably erased. The leading authority in respect of abuse of process concerning lost, destroyed, or missing evidence is Regina Ibrahim versus the Feltham Magistrates Court, Mort versus Director of Prosecutions, 2001, England and Wales, EWHC, admin 130. Now, my lords, I don't intend to take you any further than the extracts of Ibrahim that are in my skeleton, except to the extent that I may have to refer to one or two passages later, but I think the essential gist of what I need to say to you has been cut and pasted from the cases into the skeleton. And in Ibrahim, they referenced the 1997 code.
Mr. Richardson, I wonder whether we need to do this. You very, very helpfully set out the provisions of, the relevant provisions of the code,
Yes, my lord.
paragraph 77 to 81. And we've all read them.
Yes, my lord.
Do we need actually to read them out again?
The provisions of the code? No, my lord. I can skip past those.
Right.
And I can pick it up over at paragraph 82.
Yes.
Which basically sets out that although the Bermuda Police Service doesn't have a publicly available code, it's noted in Ibrahim that that code is a derivation of common law principles that judges have always considered to be proper in the guidance of police duties to collect and retain evidence. So I would hope there'd be little to no dispute on that.
Yeah.
In 83, we make a recommendation, but it's a matter for your lordships. It would be helpful, I'd say, if we could have such a code. We don't have it, but in fact, their lordships may, in this case, make the pronouncement that the 1997 code does, in fact, enshrine the right principles, and then we'll at least have some common law guidance. 84, we remain confident that this honorable court will have little difficulty accepting that the investigators in this case were under a duty to retain the voicemail evidence. The evidence clearly demonstrates the investigators' failure to preserve the voicemail message as a result of what can only properly be described as a negligent, wanton disregard for the preservation of key evidence in the course of a premeditated murder investigation. The authority of Ibrahim confirms that where the court is satisfied that the investigators were under a duty to preserve the evidence in question, the next step is for the court to assess whether, notwithstanding the breach, the defendant can receive a fair trial. The court's jurisdiction to stay proceedings in the abusive process has developed into two primary categories, of which we're all familiar. The leading authority in respect of category 2 abuse is Beckford. It is in the bundle, but I won't take you through it. Your lordships are well familiar with it. The appellant could not receive a fair trial. That's the first. We say that the learned trial judge erred when he ruled that since the prosecution could not contradict the appellant Burgess's version of events in respect of the voicemail, his directions could sufficiently address any prejudice caused to her as a result of not having the voicemail evidence. This finding, with respect, was inherently flawed. The legal test of fairness on abuse applications is to the civil standard of the balance of probabilities. In Director of Public Prosecutions versus Fell, 2013, HWAC, HC, 562, this was said, the burden of proof is on the party seeking a stay. The standard of proof is the balance of probabilities, the civil standard. The party seeking a stay must make good to the civil standard that, owing to the missing evidence, he or she will suffer prejudice to the extent that no fair trial can be held, and that accordingly, the continuance of the prosecution would amount to a misuse of the process of the court. The grant of the stay in such a case as this is exceptional. It is effectively a measure of last resort. It caters for and only for those cases which cannot be accommodated with all their imperfections within the trial process. It is, of course, a very difficult situation where evidence has gone missing through some serious culpability or bad faith on the part of the prosecutor or investigator. And we would certainly embrace that there has been some serious culpability in this case. The learned trial judge was tasked with analyzing the state of the evidence against the appellant Burgess and the position that the absence of the voicemail put her in. And that was essentially the nub of what he had to consider. He had to consider the evidence and the case that the Crown were advancing against Miss Burgess, and he properly identified that the arrowhead of that case for the Crown, in fact, the only real arrow they had in their quiver, was that she's supposed to have lured him to Derwent Lane, intending to meet him, or leading him to believe that she intended to meet him there, when in fact she never intended to be there. But on the other side, we have this evidence, which, had it been retrieved, would have clearly shown that there was never any intention to meet at Derwent Lane, and therefore there could never be any sustainable allegation of alluring. In refusing the application for a stay, the learned trial judge adopted the position that since the investigators had not retained the voicemail, this seemingly assisted or at least worked in the favor of Miss Burgess, in that the prosecution were unable to contest her version of the events. Yet still, it is clear from the summation that the issues of whether a voicemail message was actually left, and I've taken you to that, and two, what the contents of that voicemail message were ultimately left. It's a matter for you, members of the jury, and they were given no further assistance on how to deal with that. It's a matter for you. Do you think it's relevant? Mr. Cardwell didn't think so. Do you think it really amounts to anything? It's a matter for you. It was woefully inadequate on this particular important point. We submit, therefore, that the learned trial judge's suggestion that the appellant Burgess benefited from the inability of the prosecution to contest her versions of events is a wholly misconceived and misguided application of the fairness test required when considering an application for a stay. The absence of the voicemail meant that Ms. Burgess had lost the benefit of evidence independent of herself that on her case would have corroborated the statement she made to police on the 26th of October, 2006. Moreover, in addition to corroborating the statement she made to the police on the 26th of October, 2006, had the voicemail been retained and it confirmed what Ms. Burgess says it did, the jury would have been entitled at the least to reject part of or apply significantly less weight to the other evidence adduced and relied on by the prosecution, particularly the evidence of Vernon Charles, when he maintained that the appellant Burgess had told him he was going to Blue Dragon and not Lobster Pot. And I don't know if their lordships are aware, Justice Bell might be aware, but back then Lobster Pot and Blue Dragon were on the same street. In any event, Burgess had told him he was going to Blue Dragon and not
Should
Lobster
that be
Pot.
told him she was going to?
Yes,
Yes,
it
she
should
was
be.
going to Blue Dragon. Yes, sorry, my lord. She was going to Blue Dragon and not Lobster Pot. If the voice note confirmed that Mr. Charles was undoubtedly wrong on this point, and we can see from his evidence that he's far from a certain witness on this point, the jury would have been entitled to view the remainder of his evidence with equal skepticism. And his evidence, as I've shown you, was essentially the foundation for the rejection of the no case submission. B, the evidence of the Pierres, and if I have to pause there, since Vernon Charles's evidence clearly was identified by the judge as the foundation for the rejection of the no case submission, we further submit that his failure to factor in the remedy that he himself prescribed for the abuse during the no case submission was also an error. And I will demonstrate to you, and I get to that state, that he did not take it into account as he should have. B, the evidence of the Pierres that the deceased was going to 10 Derwent Lane to meet with the accused. If the voice note confirmed what Ms. Burgess said, contrary to the prosecution's case, she was inviting the accused to make contact with her, this would undoubtedly have affected the jury analysis of the case against Ms. Burgess in magnanimous ways. But for the failure to retain the voicemail message, the jury would have had the benefit of hearing the appellant Burgess's voice, analyzing her tone and candor, the cadence in which she spoke, and her overall tone. And this analysis would have undoubtedly affected, one way or the other evidence, or how the other evidence was viewed by this jury, and specifically the weight that they attached to it. Serious fault on the part of the Bermuda Police Service. We respectfully submit that this case was one that also falls to be considered a Category 2 case as well.
Could you just help me? Could you just help me for a moment? I'm slightly lost at the distinction between the case 1, where the defendant cannot receive a fair trial, and case 2, where it would be unfair for the defendant to be tried. What exactly is the distinction between them?
I believe that that distinction is set out in Beckford. I believe that's where that categorization emerges from, my lord.
Well, I'll look at it, but what does it mean?
It means, to my understanding, that in the first instance, it would be, beg your indulgence, I did set out the 2 categories.
You did? It's 87.
Yes, paragraph 87, cases where the defendant simply cannot receive a fair trial, and cases where it would be unfair for the defendant to be tried. And we say Category 2 embraces, and the authorities say that cases where it would be unfair for the defendant to be tried are cases where there has been, as we've labeled, serious
I'm just
serious fault on the behalf of the Bermuda Police Service.
I'm just having some philological difficulty. It seems to me that if the defendant can't receive a fair trial, it would be unfair for the defendant to be tried. And if it would be unfair for the defendant to be tried, he can't receive a fair trial. But
I think in Beckford, their lordships actually admit that the categories do have a degree of overlap.
I think archaeologically, the cases where the defendant cannot fairly be tried derive from those cases where, for example, a defendant is unlawfully brought into the jurisdiction. Cases like Horseferry Magistrates and Mullen and so on. There's nothing unfair about the conduct of the trial.
Oh, I see.
Place, but he shouldn't be on trial at all because he was hijacked from a different jurisdiction.
That is one example, yes, my lord.
Okay.
Well,
In fact, I sat on one of those cases in the Court of Appeal, in which the appellant's counsel began by emphasising the fairness of the trial and the faultlessness of the judge's conduct of it.
Yes.
But said that simply it should never have taken place.
Well, I follow that, but that's a distinction which I fully understand in that sort of case, but I have some difficulty in applying it to a case such as this.
Yes.
The actual serious fault principle that we rely on emerges from the case of PR, I believe, my lord.
Yes.
Which we're about to address.
Mm-hmm.
and which is in the bundle. We begin by saying we would respectfully submit that this case was one that also falls to be considered a Category 2 case as well, on the basis that the flagrant failure on the part of the investigators to retain evidence which went to the heart of the prosecution's case against the appellant Burgess constitutes serious fault on their part. On this basis, the learned trial judge ought to have stayed the proceedings on the basis that the investigators' serious breach meant that it was unfair to proceed with the trial of Ms. Burgess. The learned trial judge, in refusing the abuse of process application, referenced the authority relied on by the prosecution, R versus PR, 2019, Volume 4 of the Weekly Law Reports, page 98. We submit that the learned trial judge's ruling was inconsistent with the principles enshrined into PR. PR confirmed that the learned trial judge had a duty when assessing the prejudice caused to Ms. Burgess to consider that the voicemail represented a significant and demonstrable chance of amounting to decisive and strongly supportive evidence emerging on a specific issue in the case. And those words, my lord, beginning with represented and through to specific issue in the case, are lifted directly from PR and noted as the type of evidence which would embrace or trigger the application of this discretion. And it goes on, and on that basis should have stayed the proceedings. In fact, this was a vital issue, as I've repeated over and over, in light of the way of how the Crown put its case. In fact, at the Section 31 hearing, which we had on this matter, and my learned friend will remember it very clearly, it was the Crown's entire case in order to surmount that application, because they knew they couldn't rely on the inadmissible evidence in front of a judge. It was Justice Greaves. They relied almost entirely on the allegation, this is before the first trial, that she lured him there. That was their case, that she made an arrangement to meet him at Derwent Lane, never intended to be there. That is the importance of this voice note. The court in PR referred to a number of authorities which enunciated the principles of law to be applied to abuse applications on the ground of missing evidence, including but not limited to the following, which we've attached in our authorities bundle for ease of reference during the substantive hearing: R versus D and R versus Alvin Christopher Merrow, and the court in PR visits both cases. It is clear from the aforementioned line of authorities that in those matters, there was other evidence, separate and aside from the missing evidence, upon which the defendants in those cases could rely upon to address the prejudice caused by the missing evidence. No such circumstances existed for the benefit of Ms. Burgess in this case. So those other cases are explicable in the way that they were dealt with, in that the court in those cases, as you will see, specifically noted the other evidence that was at the disposal of the defendants. In this case, Ms. Burgess had no other evidence at her disposal except her own word, which would require her to get into the jury box and the attendant difficulties that that comes with. None of that would have been necessary had the police simply done what they were supposed to do the moment she told them, "I left a voicemail that contradicts what you're saying to me." My lords, in paragraph 103, I say, in PR, the court noted that the defendant was in possession of a substantial amount of material that could be used to test the reliability and credibility of the complainant. No such circumstances exist in this case. In Allen, notwithstanding that evidence was missing, there was DNA evidence connecting the defendant to the offense. There's no such circumstances as that which exist in this case. In RD, the missing evidence related to evidence which would demonstrate where the defendant was at the time of the offenses. The court noted that complaints in that case were not date specific, and so the missing evidence did not go to the heart of what the jury had to consider. I think in RD, the case was of an offense that took place in a Tesco, and the allegation was that the CCTV footage would have captured the offense. However, the time was determined, the time that the recording covered, it was determined would not, or the place, sorry, in the store, that the recording covered, it was determined that that wouldn't have assisted in any event. And that's not this case, because it's been conceded that there was a 33-second voicemail, and that 33-second voicemail was identified to the police in response to an inquiry of an arrested suspect as to respect to her involvement in the death of a man whose phone they had in their possession. Paragraph 106, the learned trial judge instructed the jury at pages 59 to 60 of his summation, and I just took you to it, that the delay in the instant case should be taken into account in favor of the defendant. However, he still left out to the jury to determine if, he still left it, I should say, to the jury to determine if any voicemail message was left on the deceased phone, when it was an uncontradicted fact that some voicemail message had been left. At 9:07 on the 25th of October 2006, this was yet another regrettable misdirection in that it contradicts the direction given by the learned trial judge at paragraphs 19 to 23 of page 26 of the summation, should be lines 19 to 23 on page 26 of the summation, where he directs if there are two or more inferences which may logically and reasonably draw from the same set of proven facts, then you must draw the inference which is most favorable to the defendants. In sum, the learned trial judge's directions, and I've taken you to them, did not cure the prejudice caused by the missing voicemail evidence. And as a result of the prejudice caused to Ms. Burgess, as a direct and consequential result of the investigator's serious failure to retain the voicemail evidence, the learned trial judge should have acceded to the application to stay the proceedings as an abusive process. If my lordships aren't with me on that, and I hope you are, and my lordships, we've made the submission, but I outlined it as a two-pronged submission, that if their lordships find that in the circumstances of this case, the judge was entitled to conclude that his case management powers or the trial process could cure it, he didn't go on to do that. He didn't go on to prescribe that antibiotic. He dealt with it very shortly and essentially said, ladies and gentlemen of the jury, it's a matter for you. Mr. Cardwell didn't think it was important.
Just to be clear, you say that the virus was irremediable, but if that was wrong, the wrong vaccine was used, or to use your metaphor.
If I
because
can make
what he should have said, what the judge should have said is that it's accepted that that's what she told the police was in the message. They've made no proper efforts to get confirmation of what was in the message. And in those circumstances, what, you should accept that that was what the message said?
Yes.
Would that be, could that be thought to be usurping the judge's function? Assume that for some other reason than the juror's function, the jury had decided that Ms. Burgess was an entirely unreliable witness.
But she didn't give evidence, my lord.
Well, I know.
And at that stage, her credibility would not have been an issue because the police accepted.
Yes. Yeah, okay.
So that's the difficulty the Crown faced there.
Yes, I follow.
My lord, I note it's 7 o'clock your time. I'm not sure how long you wanted to process.
Well, we were thinking of going on till about 7:30 our time.
Another half an hour, sure.
Is that all right with you? There's quite a lot to get through in this case.
My lord, I think I can deal with the no case to answer ground before we conclude.
Okay, well, let's do that.
Doesn't require any immense descent into case law. It's a pretty common sense submission. Yes.
Well, if you're happy with that, let's do that. And if you find you can't, we'll have to break off.
No, my lord, I think I can. If you go to paragraph,
in a sense, you've covered this ground at the early stage of your submissions, when you were talking about what the prosecution had to prove and submitting that they hadn't done so.
I did do that, my lord, but I don't think I've done it with the thoroughness that my
I appreciate that.
Yes, my lord. So I've been with that guidance. I will move fairly quickly through this section, but I will try not to rush. At paragraph 108, it is trite law that dealing with a no case submission. We know what the test is. I won't repeat that. What I might add is that we're also very well familiar with the popular gloss put on the Galbraith test in the case of R versus Shippey. And the classical quote is that a judge, when conducting a no case submission, shouldn't accept the plums and leave the duff behind. And this was definitely the type of case in which the judge had to consider the plums and the duff. The court must assess whether a jury, when properly directed, could properly draw the inferences and conclusions which the prosecution seek to rely upon to make a finding of guilt against the accused. And at the no case stage, essentially the judge is directing himself in the way that he would direct a jury and asking himself whether a jury who follows these directions that I'm now giving myself would properly be able to safely convict an accused. That's essentially the question that he's asking himself. And if he finds that he's in doubt as to whether or not that can happen, the totality of the no case principle is he should stop the case. When considering the no case submission advanced on behalf of the appellant Burgess, the learned trial judge had to apply the tests laid down in Galbraith and the gloss in Shippey. We say that there was absolutely no evidence, and on every occasion when we say evidence, we mean no admissible evidence against Ms. Burgess before the learned trial judge at the no case stage that Ms. Burgess planned the premeditated murder of the deceased together with Cleveland Rogers. The learned trial judge allowed the confession evidence, we say, which was inadmissible against the appellant Burgess, to cloud his judgment in assessing the case at the no case stage. We assert this owing to the fact that there was, one, no evidence capable, no admissible evidence against Ms. Burgess, capable of establishing that the appellant Burgess had planned anything with Cleveland Rogers, let alone a murder. B, there was no evidence admissible against Ms. Burgess, capable of establishing a relevant connection between Cleveland Rogers and Ms. Burgess around the time of the murder, i.e. no phone evidence, no cell site data, no eyewitness evidence placing them together moments before the murder, nothing of that sort. C, there was no evidence admissible against Ms. Burgess of any intention to kill on her behalf. The contention is that she aided, there's no contention, I should say, that she was at the scene, assisted in the stabbing in any way. And this connection is totally dependent on an inadmissible confession. D, there's no evidence admissible against Ms. Burgess supporting the contention that the appellant Burgess knew that Cleveland Rogers would be at 10 Derwent Lane on the night of his murder. Absolutely nothing admissible against her. In fact, those 4 points, the evidence, any evidence at all in this trial, which might point in that direction for Ms. Burgess, emerges from an inadmissible confession. Simply put, paragraph 113, I'm at now, my lords, the court was faced with a paucity of admissible evidence in respect of the case against Ms. Burgess, and the only rational explanation, we say, for the learned trial judge's decision to refuse the no case submission on behalf of the appellant is that he erroneously allowed his judgment to be clouded by the confession evidence, which was inadmissible against Ms. Burgess. We are sympathetic to the reality that the learned trial judge, in the circumstances of this case, may have had serious trouble separating the cases of the accused. However, we submit that this fortifies the contention averred in ground one of this appeal that separate trials should have been ordered. Putting the inadmissible evidence to one side, the prosecution's case against the appellant Burgess amounted to no more than the allegation that she was a scorned woman who had, without prejudice to the abusive process argument in respect of the 9:07 p.m. voicemail message, we're not factoring that in, arranged to meet her former boyfriend at their old apartment and did not show up. The statements alleged to be made by Ms. Burgess to the deceased mother advanced the case no further in that it did not establish or satisfy the requisite elements of the offense of premeditation, namely an intention to kill, which founded her decision to arrange to meet the deceased. There's no evidence of that. A common purpose with Mr. Rogers to kill the deceased. There's no evidence of that except that which emerges from the inadmissible confession. And it's easy to forget that that's where it comes from. C, knowledge that Mr. Rogers was waiting at 10 Derwent Lane to kill the deceased. All of these things had to be proven on her behalf, but there's no evidence in this case to prove any of those except that which emerges illicitly, wrongfully from the confessions supposedly given by Mr. Rogers. There's no way around that. The admissible evidence against Ms. Burgess did not in any material way involve Cleveland Rogers at all. So it is, with respect, and it beggars belief, that the trial judge refused the no case submission. Putting the fact that there was no evidence whatsoever that Ms. Burgess knew or arranged for Cleveland Rogers to be waiting at 10 Derwent Lane, there was no evidence of any intention to kill on the part of Ms. Burgess, nor was there any evidence upon which her intention could be properly drawn. My Lord Kay and I had a discussion earlier, but I maintain my position. Any suggestion that there was evidence from which it could be inferred or the inference could be properly drawn that she had an intention to kill would be speculation. The learned trial judge appears to have erroneously accepted that the element of intention to kill could be inferred by the fact that the deceased was subsequently killed. In fact, in the summation, and I'll take you to it, he demonstrates, he says that don't think any counsel are disagreeing that the person who stabbed Mr. Gibbons intended to kill him. Well, I think he's forgotten that my client isn't the one who stabbed Mr. Gibbons, and an intention needs to be proven on her part as well. His contention with respect is inherently flawed. There must have been some admissible evidence upon which a jury, properly directed, could safely conclude that Ms. Burgess made that call with the intention of procuring Mr. Gibbons' attendance at 10 Derwent Lane for no other purpose than to have him killed, because the charge is premeditated murder. Not simple murder, where GBH will do, not manslaughter, premeditated murder. The learned trial judge at paragraphs 14 to 25, and I think that's lines 14 to 25 on page 77 of the summation, directed the jury that they should have little difficulty accepting that the person who stabbed Marcus Gibbons, causing the injuries you've heard described, had any other intention in mind but to kill Marcus Gibbons. So again, that should not, I think, cause you any difficulty. I'm going to need to take you to that passage. Page 77. Remember not to move too far over to the side. Yes. It begins at page 77, as indicated in the skeleton. It does begin at about line 14. And it reads, my lords, again, I do not think in this case there is any issue taken by the defense for either Mr. Rogers or Miss Burgess that the person who stabbed Marcus Gibbons, clearly not Miss Burgess, causing the injuries you heard described, had any other intention in mind but to kill Marcus Gibbons. So again, that should not, I think, cause you any difficulty. Now, preceding that, his lordship does give a direction on what premeditation means, but what is missing is any analysis by his lordship of the evidence which would be admissible against Miss Burgess, which would assist the jury in determining whether she had that premeditation. There is a vacuum on that. And we begin at page 75. And at 75, his lordship has gone through the elements in the preceding pages. And the sixth element he deals with is that the killing must have been committed with premeditation. And he says that at the bottom of page 75. Over at page 76, he says, for current purposes, premeditation is defined in section 286B of our criminal code as being established by evidence proving, whether expressly or by implication, an intention to cause the death of any person, deliberately formed before the act causing the death is committed and existing at the time of the commission of that act. So in this case, the prosecution must satisfy you beyond a reasonable doubt so that you feel sure that the defendant had the specific intent to kill.
Defendants, plural.
Defendants, sorry, had the specific intent to kill. That is, the intent to cause the death of Marcus Gibbons and that they have formed that intent prior to and still existed at the time of causing his death. That's a correct statement of principle. But our submission is, as you will notice, that those correct statements of principle have to be tied to the facts of the case if they're going to have any real applicability in the minds of a jury. It is not enough, for example, that the defendant intended to do Marcus Giving some harm, no matter how serious, short of death. It is not enough, for example, that the defendants intended to do Marcus Giving some harm, no matter how serious, short of death. They must have specifically intended to kill Marcus Givens. It is not necessary, however, that an intention to kill exists for any particular length of time in order for the killing to be premeditated, prior to the actual killing. It is only necessary, as I say, that an intention to kill was formed at some point prior to the killing and continued to exist at the time of the act causing death, in this case, the stabbing of Marcus Givens. Now, in that analysis, if intention to kill, the premeditation didn't arise until after Mr. Givens and Mr. Rogers, if that's what is accepted, were in proximity with each other, then there'd be no evidence and it'd be impossible to assert that Ms. Burgess was part of a prearranged plan to kill someone with an intention that had not yet arisen. That's a serious difficulty. He went on, now I've already given you a general direction in respect of intent, and you cannot, as I've said, surgically open up a person's head and extract it from their head or intentions. And to complete that thought, my lord, having given the jury that direction, it was incumbent on his lordship to give them a practical example as to how they would apply that if they found that the intent to kill, if they weren't satisfied so that they felt sure that the premeditation existed before the luring. If they weren't satisfied, then they would have to consider the case a different way. And they would have to have found her not guilty because she would not have been a party to the premeditation. There are very serious difficulties with this direction in that it is not going far enough. I've already given you a general direction, Inspector Pertain. You cannot surgically open up a person's head and extract it from their intention or intentions. Instead, you must decide a person's intent by considering all the circumstances. What did they do or not do? What was the effect of their actions or inactions? What did they say? Look at the nature of their words and actions prior to, at the time of, and after the alleged offense. All of these things may shed light on the state of their intentions. Again, I do not think in this case there is any issue taken by the defense for either Mr. Rogers or Ms. Burgess that the person who stabbed Marcus Givens, causing the injuries you've heard described, had any other intention in mind but to kill Marcus Givens. So again, that should not, I think, cause you any difficulty. And I've now, by going back, put complete context on all the directions the Lordship gave about premeditation. And my lords, I think you can see just from a cursory perusal that there are gaping holes in that direction when it comes to Ms. Burgess. Essentially, the judge did tell the jury, well, whoever stabbed this guy, well, yeah, that was premeditated. But it doesn't take into account the fact that premeditation could have arisen after a luring if they found that that took place. But worse than that, we go back to our first submission, there was no sufficient evidence of a luring to begin with, especially in light of the fact that no account was given of how the missing voicemail would change the picture. I return now to the submissions at 120. The forensic evidence in this case revealed that there was clearly a struggle between the deceased and the murderer. That's no dispute. In fact, that is the Crown's position. No jury properly directed could be sure beyond a reasonable doubt that Ms. Burgess arranged for the deceased to attend Durant Lane for no other reason than to have him killed. Any such finding would respectfully require the jury to speculate. The learned judge was wrong to direct the jury that whoever murdered the appellant had no other intention in mind but to kill him. There was no evidence to support this regrettable misdirection. It could not, we submit, be reasonably excluded that whoever killed the deceased had another intention other than to kill the deceased. That the deceased was ultimately murdered does not relieve the prosecution of its burden to prove the crucial element of the offense, namely premeditated intention. For instance, let me give this example, and this was reasonably open on the evidence. In fact, it almost cried out from the direction that the learned trial judge took for him to do this. If the evidence admissible against Ms. Burgess went as far as to say that she invited him to Derwent Lane, and that's as far as it went, with the view that Mr. Rogers would be there, the other clearly open inference, if the Crown's contention is that this is her brother and she wants her brother to like have a word with this guy, maybe confront him. There are all sorts of plethoras of intentions that could have been present if there was an arranged meeting. And how would she be responsible for premeditated murder if at that arranged meeting, words were exchanged between men and a struggle ensued, as the evidence shows did take place? Then she would not be on any analysis liable for premeditated murder. In fact, on any analysis, it might have been a manslaughter. It might have been a simple murder. But here's the problem: we don't know. And the jury were given no guidance on how to deal with that very layered reality that was before them. His lordship gave almost no guidance on those very essential issues, especially in the case where the Crown did not charge, state, and they were invited to leave an alternative and didn't. I think we discussed leaving an alternative, and the Crown nailed their colors to the mast. This is premeditated murder, nothing else. At paragraph 125, simply put, the evidential link between the appellant Burgess and Cleveland Rogers did not form part of the admissible evidence against Ms. Burgess. And I need to repeat that. The evidential link between Ms. Burgess and Cleveland Rogers, as it relates to this particular offense, did not form part of the admissible evidence against Ms. Burgess. Instead, it came from the inadmissible confession evidence that was proffered against Mr. Rogers. It could not have come from anywhere else. And putting aside for a moment that there was no direct evidential link between the two accused in respect of the prosecution's case against Ms. Burgess, other than the inadmissible confession evidence against Mr. Rogers, what would be the case if Ms. Burgess had arranged for her brother to be there to talk to the deceased, and the two of them, the deceased and Mr. Rogers, got into a confrontation, resulting in a struggle? This evidence of a struggle was before the jury by way of forensic evidence that subsequently resulted in the deceased succumbing to his injuries. Of course, the court might rightly find that the aforementioned scenario is nothing more than speculation, but here's the problem. So too was the Crown's case against Ms. Burgess, and in the latter scenario, as with the case that was before the learned trial judge, a case of premeditated murder, which requires a pre-existing intention to kill before and at the time of the commission of the offense, was just plainly not made out on the admissible evidence before the judge at the no case stage. In fact, at the no case stage, the judge doesn't even mention or address the elements. He doesn't even ask himself the question whether there's evidence of premeditation. He simply finds, well, hey, Brennan Charles's statement, that's the highest of the Crown. It seems to say she lured him there. That's the end of the matter. That was a fatal error, my lords. And I'm not entirely certain that it can be cured. And that no case submission should have been granted. At paragraph 128, the learned trial judge instructed the jury at pages 59 to 60 of the summation that the delay in the instant case should be taken into account in favor of the defendant. However, he still left it to them, and he failed, we say at this stage, my lords, to take into account the fact that there was evidence before him, this would be the duff, of a voice note that the police negligently did not retrieve, which has the potential of running a coach and horses, if true, and he should have assumed that it was, through the case advanced by the prosecution. At no point during the no case submission does he even take that into account, after saying at the abuse, in the abuse ruling, that that is something I can do, I've been asked to do, to factor it into my ruling on the no case, but yet he fails to do it. That was another regrettable omission by his lordship, which led to him wrongly rejecting the no case submission. Notwithstanding the fact that the learned trial judge did not see fit to exercise his discretion to stay the proceedings on the grounds of abuse, when he came to consider a no-case application, my lords, he had a duty to apply his direction that inferences which may logically and reasonably be drawn from the same set of facts could be found in favor of the defendant to each tenuous circumstantial strand of the prosecution's case. In this regard, the learned trial judge should have specifically borne in mind his obligation to apply the circumstantial evidence direction as enunciated in the authority of the House of Lords versus Tepper, and which was recently considered in Kelly, in which Pitchford, Lord Justice, made the following observation: the risk of injustice that a circumstantial evidence direction is designed to confront is that speculation might become a substitute for the drawing of a sure inference of guilt. And two, the jury will neglect to take account of evidence that, if accepted, tends to diminish or even exclude the inference of guilt. Tepper is authority for the principle of law that before drawing an inference of the accused's guilt, a jury must be sure that there are no coexisting circumstances which would weaken or destroy. This circumstantial evidence direction, coupled with the direction to find all equally logical inferences in favor of the appellant, Ms. Burgess, leads to the unassailable conclusion that no jury properly directed could safely convict or could have safely convicted her on the evidence before the learned trial judge, and the learned trial judge ought to have stopped the case at that stage, my lords. That does bring me to the end of the no case submission.
Yes. Very good. Well, thank you very much. That probably is therefore a convenient moment to adjourn.
The next ground is the one that you're not pursuing, isn't it?
The next ground, it may be headed, hearsay. No, that is the ground that we are pursuing.
No, that is the ground you're pursuing.
That is the ground we are pursuing. It is not a long ground. It is a short ground. It is the ground which is foreshadowed in Hayter and for which there is authority that particular mechanism was open to his lordship. I shouldn't take long with you on that ground tomorrow.
No.
The jury pressure ground, that needs to be explored and discussed, and that would bring me to the end of my submissions, my lord.
I thought you
Right.
did say, Mr. Richardson, that you weren't pursuing ground 4.
I'm not pursuing ground 4. Ground 5 is a different ground, my lord.
There is no ground 4 in the skeleton submissions.
No, it's referred to in paragraph 3, but that's
Yeah.
And that's what I tried to explain at the beginning. We noted ground 4 in the notice, but we didn't make any submissions on ground 4 because, as we should have formally noted, we didn't intend to pursue ground 4.
Don't let me wait. Sorry. Yeah, quite right.
Very good.
Yes, my lords.
Thank you. Well, we will adjourn until 9 o'clock your time tomorrow, 1 o'clock ours. And Mr. Richardson, thank you for dressing properly. You needn't feel the obligation to have bands tomorrow. We have largely proceeded on the basis that if we're doing Zoom hearings, since we're not properly dressed, you don't need to be properly dressed either. But feel free
Thank
if
you.
you wish to.
Thank you. I wish my lord would have said that just before 12 when it was really hot.
No, I'm terribly sorry. I should have done.
That's fine.
It's only mildly warm in London at the moment. Right. Well, we shall see you all tomorrow.
Yes, thank you, my lord.
Thank you very much. We'll break out if we may.